He has such a long time to go. So many days. I wonder, is the music too loud?
I'm going to keep to what I've always done. As long as senators have questions, process as you may, your extended family and all my colleagues. We're going to try our best today to go through this process. Judge, it may be hard for you to believe, but there's some members up here who are as anxious to finish this process as you may be, although I doubt there's anybody as anxious as you are. But what we're going to do today is we're going to try our best to see if we can finish today. Based on what we announced on Tuesday, I told senators they would not be kept late today so they could make plans for their events in the weekend. There is a possibility we can finish this thing by 4 or 5 o'clock. If we finish it, that's my objective. I hope we do that. If we do, we finish. If we don't, and there's senators who still have questions, then I'm going to ask you to come back on Monday. I don't anticipate that. I hope we don't have to do that, but that's where we are right now. I tell you that at the outset. And what we're going to do, the Chair would suggest that we'll have, unless you tell me otherwise, I would like to proceed essentially as we have in the past. We'll go for an hour with senators and then take a short break, and we'll essentially do that. And if it looks like as we go on this morning that we may be able to finish today, we'll shorten the lunch break to see if we can do that. But again, I've done more of these hearings than I want to recall, and I have the fervent hope for the good health and longevity of everyone on the bench. I don't want to do any for a long time hence, but I'm going to keep to what I've always done. As long as senators have questions, and they are not badgering, and none have, in my view, we will continue the process. With that, let me yield to my friend from South Carolina, who I understand wanted to make a statement before I yield the floor to Senator Leahy for his questions.
Thank you very much, Mr. Chairman. I think you anticipated what I was going to say and have already agreed to do what I wanted to do. That is to finish today. I want to say on this side, we have only one senator who will take his 30 minutes, another one who will take 5 minutes, and so it'll be only about 35 minutes on this side, and I feel certain we can finish today. I remember with Judge Souter, we took only 3 days, and this will be 4 days with this witness, and I think that's reasonable. And I thank you for your cooperation. I feel certain we can finish today.
Senator from Pennsylvania.
Thank you, Senator. Affirmative.
On the third round, I said second round, third round.
On the third round? Well, just wanted to be sure that Senator Thurman had not intended to commit this Senate.
Oh, I have not precluded you. I told you a while ago you could talk. You'll be the only one that's going to talk. I'll give you the whole time except 5 minutes.
Well, I'm still in some doubt, Mr. Chairman, but I just want to say for myself that I want to see how it goes without making a commitment at this time as to limitation. I want to cooperate with the chairman and with the ranking member in finishing today if we possibly can. I think that's a worthwhile objective, and I want to cooperate toward that. But I do not want to be committed as of this moment until I see how my second round of questioning goes. I've only had one round.
The one thing I have found, I'd say to the Senator from Pennsylvania and to the committee, that of all the senators, probably the person who talks the least but asks the most questions to seek information and never has wasted the committee's time is the senator from Pennsylvania. Now, let me yield to my friend from Vermont, who also never wastes the committee's time.
Thank you, Mr. Chairman. Judge Thomas, welcome back to you, Mrs. Thomas, and your family. Judge, you know, there's been a lot said by commentators and written about what the purpose of these hearings are, and I've been discussing this with friends of mine back in Vermont. They sort of asked what we're doing. I mean, is it kind of a question where we'll all ask a certain question and you'll get back a response, however prepared, and that can be kind of a stylized ritual. I think the press probably correctly reported, even in advance of the hearings, how some of the questioning and how some of the ritual might go in here. But I think that if these hearings are to be important for all of us, for me as a senator and for every other senator, it requires us to have some idea how you think. I mean, when you go to the Supreme Court, none of us are asking you, for example, how you're going to rule on an upcoming case. Like, everybody agrees, and that all members of the committee, that's an inappropriate question, and you wouldn't answer it if we did ask such a question, how you'd rule an upcoming case. But it is appropriate for us to ask you how you think, what your background is, what kind of a justice you might be, if the advice and consent clause means anything. The President is asking us to confirm you to a position, an extraordinary position. There's really no Supreme Court like ours in the world. There's lifetime positions, enormous power, equal branch of government. In fact, in some ways more than equal, because it becomes the arbiter between the other two branches of government. And each of us, whether conservatives, liberals, moderates, north, south, white, black, whatever we are, as Americans, we can always say to ourselves, if somebody tramples on our rights, I can go to the Supreme Court. I'm an American. I can go to the Supreme Court. And I think most Americans want to know whoever sits on that court is somebody who is going to look at their case and is going to have the qualities and the qualifications and the background and the integrity and the impartiality to look at their case and decide on the merits of that case. So with that in mind, because I still have a difficult time even having met with you, and I think I've been here for about 95% of the time you've been in this room, I still don't have quite the sense of how you think and what you would be as a justice. So bear with me if I might ask a kind of a general question. Judge, you entered law school 20 years ago this year. And in that 20 years, as both you and I would agree, there's been some extraordinary cases in the Supreme Court. They've actually decided hundreds of cases, made rulings perhaps in hundreds more in that 20 years, but some may be routine, but some have been pretty significant cases. Just tell me, because it'll help me know how you think, what would you consider a handful of the most important cases that have been decided by the Supreme Court since you became a law student 20 years ago?
Senator, it would be, to give you a running list, I would have to go back and give it some thought, but I certainly think that during the time that I was in law school, two of the cases that were considered the most significant cases, or among the most significant cases, would have been certainly Griggs, was decided while I was in law school, and Griggs.
Yes.
And certainly, I think Roe versus Wade. As you know, during that time when I was in law school, there was significant debate with respect to the inclusion and the rightful inclusion of women in the legal profession, as in the law school, in higher education. I know, for example, my own college, which was all male when I attended, had become co-ed. There were just very rapid changes, so that certainly would have been a significant part of that change.
So you take Craig versus Boren, is that?
Craig versus Boren also, that would have been during law school, but you know, I think that one certainly isn't as routinely used in the press as...
Are there some other cases that come to mind?
There would be other,
Senators.
Senators. I can't, off the top of my head, as you mentioned them, perhaps I could accord some weight to them. I just not off the top of my head.
But there are none that sort of stand out that might have been cases that have influenced your thinking when you accepted the appointment to the Court of Appeals, or when you accepted this appointment, that certain things stick in your mind, say, I'm being nominated to the court that decided whatever the case might be?
Oh, before my lifetime, I'm being nominated to the court that decided Brown.
What are some of the other?
And I think I mentioned that when I was when the president made the announcement that I would be nominated to the Supreme Court. That's certainly one of the cases, even before I knew all of the legal ramifications. It's one that changed my life and changed the South. And of course, even though I did not go to desegregated schools until I was virtually an adult.
Well, let me ask you about some of the recent cases that have occurred since you were in law school. One, of course, very recent one, Russ versus Sullivan. And that was a case where the court upheld the regulations prohibiting abortion counseling or referral in the Title X family planning program. Now, I'm not going to ask you to go into the particulars of that case because it's still a matter of some controversy, but I'd like to go into some of the issues raised about it. One is whether the government can require a recipient of federal funds to express only those views that the government finds acceptable in any broad area. And I'm obviously thinking of some of the First Amendment ramifications. Let me make some specifics, examples, and these are not cases that are about to come up before the Supreme Court, so let's talk just in the abstract. Suppose the government wanted to further a policy of participation in the political process. Could they give out subsidies but limit them just to people who say that they will vote Republican, or just to people who say they vote Democrat? Could they do something like that?
Senator, I certainly couldn't absolutely answer that. I would be concerned that if the government could do that, it certainly would seem to me to be an interference with the way the freedoms that we would expect in our political processes, as well as the way that we think that we can function as citizens in this country.
Well, let's go to another example. Suppose the government, laying out as we're going to have a government policy that we want to protect the public from sexually explicit material, So we say if you're a library and you receive public funds, well, then you can't have certain listed books. You can't have Alice Walker's The Color Purple. You can't have J.D. Salinger's Catcher in the Rye available. Could we do something like that?
Again, Senator, I would have the same concern. I think the underlying problem that the court has wrestled with, and I'm certainly in using the receipt of federal financial assistance to in some way determine what policies would be, that this body would have to wrestle with also. And I think that the first that those sorts of issues arose, to my knowledge, in a general way, would have been in the Grove City case, where there were some concerns, at least the argument may have been raised by the educational institutions, and the court disposed of it. But the concerns would always be whether or not the government is conditioning the exercise of constitutional rights or the exercise of the engaging of conduct that we think that we're free to engage in this society under receipt of federal financial assistance.
But you understand, and you would accept, of course, the fact that there are times when the demonstration of government policy or the requirement of government policy can conflict with the basic constitutional rights of freedom of speech. I mean, this has happened in our history certainly over and over again, has it not?
I think that particularly, Senator, with the significant involvement today of government in virtually every aspect of our lives, that the potential conflict of between the government's policies or between the government and rights that we consider fundamental to us, or rights that we have considered those that we've been free to exercise, where that conflict, there's more of a potential for that conflict today. And I think that we all have to be on guard when the occasions arise, when the conflicts are such that fundamental rights are in ways are either denigrated or conflicted or undermined or interfered with in some way.
You mentioned that some of these are issues that we have to wrestle with here in the Congress, but there is more and more of a feeling that we're going to send money, federal taxpayers' money, we're going to put strings on it. Now, some of those strings can, I think most people would accept, make sense. Certain, if we put accounting strings, you got to count where the money goes for. I don't think anybody disagrees with that. If you say road building funds must be used for road building and not for something entirely different, we understand that. But what happens when we go to the next step and say, okay, we're going to send money for a significant purpose. But by gosh, we're going to tell you how to think if you use that money. For example, say the government says we're in favor of nuclear families. Fine, good statement of policy. But then do we also say now to any college receiving federal funds, and most do in one way or another, you can't include information in a sociology course on divorce or illegitimacy or homosexuality or heterosexuality or whatever, because we feel it would interfere with this policy. Can we do that?
Senator, I think that as you move more into freedoms that we consider fundamental, I think that, as I've noted earlier, that the conflict becomes more accentuated. And I think the conflict becomes more evident. And to my knowledge, in those kinds of instances, the Supreme Court has to wrestle with whether or not the government has, if it's a fundamental right involved, for example, whether or not the government has a compelling interest in doing that. I understand the concern, but I can't in each specific instance say that I can resolve the problem. Or the specific problem. But I would have deep concerns myself. As someone said that in order to receive financial assistance, you're going to have to conduct your life in a particular way.
But what standards? What I'm thinking of is this, Judge, what standards is the court use? Because you're going to become the arbiter in such things. If the Congress sits out and says, here's our money for good use, education, health, research, whatever. But in effect, we're also going to tell you, based on whatever congressional mandate might be, a 51-vote mandate maybe in the Senate or more, we're going to tell you how to think. Now, when that happens, if the Congress does that, people are going to resort to the courts. I'm not asking you to prejudge a lot of cases, but what basic standards, if you were to lay out, if you looked at a case like that, we've sent money for a very valid reason, for sake health care or education. But we said, here's what you can talk about, and here's what you can't talk about. Here's what you can read, or here's what you can't read. What standards would you, as a judge, use to develop, to determine whether we have just set aside the First Amendment?
Senator, let's, I guess, generally, and we're talking, I guess, in the very general terms, if the right involved, of course, is a fundamental right, of course, that the appropriate tests would have to be the demonstration by the government that there's a compelling interest in some way infringing on that fundamental right. But let me underscore one other point that does not quite get to that, and that would be a part of any analysis when this body expresses its intent to regulate a particular area or to provide assistance in a particular area, and that is accomplished in the administrative agencies. When those agencies develop their regulations in the areas that do not touch upon and do not involve the fundamental right, of course, we would have to defer to some extent to the agency and certainly to the intent of the reasonableness of the agency's regs, and certainly the intent of this body. The separate test that I mentioned initially is to the extent that it does infringe upon a fundamental right. I think the court would have to undergo the standard kinds of analysis involving the compelling interest tests, for example. In other words, hold the government to the very highest standards to show why it can or why it has an interest in infringing on these rights.
Judge, in my earlier question, when I asked you about what you considered some of the most important cases that have been decided since you were in law school, and we went to the next thing, what consider some of the most important cases, period, and you had mentioned Brown versus Board of Education, and I absolutely agree with you. This is one of the most important cases certainly decided in my lifetime. But it triggered my mind a little bit because you gave a speech once, and you said that you considered Morrison versus Olson, that's a special prosecutor case, as the most important case since Board of Education. Now, you didn't happen to, when I asked you about cases, you didn't list Morrison this morning, but in your earlier speech you said this is one of the most important cases since Board of Education. Now, that upheld the special prosecutor. But in that speech, you weren't very kind toward it. You said it was a very important case, but you didn't like it. You called, there's a 7-1 decision, Justice Scalia dissented, you called his dissent remarkable, but you said that Chief Justice Rehnquist's 7-1 decision failed not only conservatives, but it failed all Americans. Now, I was surprised that you didn't list this as one of your most important cases this morning, but let me ask you this specific question about it. Do you feel still today that Chief Justice Rehnquist's decision failed all Americans?
Senator, as I indicated yesterday, the point that I was making there with respect to that speech, and certainly in the rhetorical language, was this: that the structure of our government, as I saw it, and again I gave that speech as chairman of EEOC, was to protect individuals. In other words, the government is arranged in such a way that individual rights and individual freedoms are infringed upon as little as possible. And the point that I was making was that when that structure was changed and when there was a prosecutor that was not accountable to either one of the political branches, directly accountable, that could violate individual freedoms in a way that the three-part government that we have, the three branches, would not permit and would not allow.
Well, you actually said that the special prosecutor statute could actually undermine the individual freedom of the person who's being investigated. But the reason you said you gave that speech and the rhetoric of it as chairman of EEOC, but you were also at that time a lawyer and one who's thought about these issues. And what struck me is that when you link it really with Brown versus Board of Education, a case which all of us look as a most significant case, in which you would have certainly strong and personal reasons, as you have eloquently stated, for supporting it. When you put them together, it concerns me because in your testimony, you stated over and over again how you want, even in your testimony here, to guarantee your impartiality. But isn't that what the special prosecutor is about, to make sure that if there is serious wrongdoing in the executive branch, Iran-Contra, Watergate, whatever, that there is an impartial prosecutor? I mean, should a president be in a position, for example, as President Nixon was in 1973, to be able to fire the person who's investigating him?
With respect, Senator, to the discussing that case in comparison with Brown, as I noted yesterday, the point was to take a case that most considered obscure and elevate it and attempt to show some of the significance of that. The important point that I was making is, as I told you, that individual freedoms were at risk. I wasn't looking at the case per se as a lawyer to argue the next case. I was looking at it in the context of the political theory and philosophy that I was discussing at that point.
Well,
if you notice, I did not parse the statute per se. Another point that I would like to make is that at that time, when we're in the political branch, I think that we advocate for the political branch. I've made comment throughout this hearing that when one moves to the judiciary, one must remain neutral in any debates between those two branches. And I certainly have done that in my position as a judge on the Court of Appeals, and would intend to continue to do that. And as you added, that this is a 7-1 decision, as I noted to Senator Kennedy yesterday, I believe that this is the Supreme Court has spoken. It's the law of the land.
But you also have I agree with you on the question of impartiality, but you would accept, I would assume, that people don't expect the second a judge puts on a robe that it's like an eraser going across a blackboard and their whole life is wiped out, all their thoughts, all their feelings, their prejudices, and I don't use that in a pejorative form, but just all their feelings they have toward everything is suddenly wiped out. And again, it goes back to what I said before. We're trying to see how you think, so that the American people know how you think, because there's a great deal at stake for all of us, and you or any member of the Supreme Court. You are one of only 9, and You're one of the three equal branches of the government. Let me ask about a very important habeas corpus case that was decided this past term. That was McCluskey versus Zant. Now, I've seen your speeches and writings, and I understand your feeling it's one thing to write in the executive branch and all, but you've frequently attacked what you call the run-amok liberal judges. Well, McCluskey, they said the state prisoners should be limited to one bite at the apple in federal court. I don't want to go into so much of the result of that. I mean, as a former prosecutor who had to face an awful lot of habeas corpus things, I felt that the nibbling ought to stop after a while. There ought to be a limit on it. That's fine. But I look at this case, which is sort of hailed as the steps of a good conservative court, is probably falling into exactly what you're talking about in these judges running amok. In 1989, the Chief Justice appointed a committee that was chaired by former Justice Lewis Powell. And the Powell Committee was supposed to study the possibility of limiting the constitutional right to habeas corpus appeals. They testified before our committee, did a great deal of work on it. In fact, they came up with a proposal which would have sharply limited the right. Now, the 101st Congress considered these proposals, did not pass the legislation that would enact the Powell Committee's proposals. For whatever reason, the legislative proposals were not enacted. So after we didn't, this spring, the Supreme Court went ahead and, in effect, did the legislation themselves in the McCluskey decision. Is that judicial restraint or is that judicial activism?
Senator, could I address one point you made first, and then Justice, and second? With respect to judges and what happens when you become a judge, I quite frankly don't know that any of us who, prior to becoming judges, understood exactly how it would change us. I could not have told you when I was here for the Court of Appeals exactly how it would change me. I can tell you, and I think most judges would tell you, that it's not necessarily like an eraser, but it is a profound change. With respect to the comment that the question and the concern that you raised about that case, I think that activism, going beyond either the legislation or beyond the law on either side, is inappropriate. I don't think that any brand, whether it's conservative activism or liberal activism, if I could use those two general categories, is appropriate. A judge is to remain impartial. I believe that it is one thing to sit in the executive branch and to take policy positions and to advocate and to disagree with the court and to challenge the court. It's another thing to be the judge and to be called upon to be the final arbiter in some of the most difficult cases in our country. And I think neutrality is absolutely essential.
Judge, obviously I got dozens of other questions, but I just realized as the time is running down, I don't want to leave one that we talked about before. I assume by now you've had a chance to read the Lehrman article. I see it sitting there, so I didn't want you to be disappointed, because I want you to have at least one question that the quarterbacks behind you have been expecting here. You have read the article.
Yes, I have, Senator.
Thank you. So have I. In 1987, you called that article a splendid example of applying natural law. Louis Lehrman's analysis concludes that because the right to liberty attaches at conception, that abortion, any sort, is unconstitutional. Do you agree with that conclusion?
As I indicated, Senator, to you in our last discussion, I have read this article, and as I have noted throughout my testimony and in discussions in reference to this article, my only interest was, as stated, to demonstrate to a conservative audience that one of their own used this notion of natural rights. And the second point is that, as I have indicated, I do not endorse that conclusion. I do not think that, and have said it, that the declaration or the argument should be made in this fashion, and I have not concluded in any way or reached these conclusions or endorsed this conclusion.
I'm not sure just which conclusion we're talking about. I'm talking about Lehrman's conclusion that all abortion, under any circumstance, which of course would go way beyond any overruling of Supreme Court decision or anything else, but his conclusion that all abortion is unconstitutional. Do you accept that conclusion?
Senator,
I'm not trying to play word games with you, Judge. I'm not sure whether it's the natural law or the conclusion that you disagree with. Do you agree with his, let me ask you this specifically, do you agree with his conclusion that all abortion is unconstitutional?
And what I'm trying to do, Senator, is to respond to your question and at the same time not offer a particular view on this difficult issue of abortion that would undermine my impartiality. The point that I'm making is that I have not, nor have I ever endorsed this conclusion or supported this conclusion.
Thank you, Mr. Chairman. I know my time is up, and I would not want to intrude on anybody else's time, but I'll hold my other questions for the next go-around. Thank you, Judge. Appreciate it.
Thank you very much. I apologize, Judge. It wasn't that I lacked an interest in listening. I'm trying to find out what senators have to catch what planes at what time so we can avoid this seniority route to get people to have a chance to ask their questions if we get that far. Now I yield to my colleague from Pennsylvania, Senator Specter.
Chairman. Judge Thomas, one of the reasons that I was pleased to see your nomination was because of your background in civil rights work and employment opportunities, because equality of employment is so very important for the future of America. And I had asked you in the first round questions about affirmative action and about the cases and your positions. And I know that early in your career, you took the position that flexible goals and timetables were desirable. And later, you have shifted away from that. We all agree that quotas are bad, but you had said in your 1983 speeches that you thought flexible goals and timetables were good. When you and I finished my first round on Wednesday, I had started to discuss the Supreme Court decision in the sheet metal workers case and had not had a time to really outline the facts. And I had raised the question as to why you opposed the remedy in that case, because it was such an egregious, such a very bad case on discrimination. Very briefly, the facts are these. In 1964, the New York State Commission found discrimination against blacks, and the New York trial court ordered changes. 1971, federal litigation was started to stop discrimination. 1975, the federal court found discrimination in bad faith. It was upheld by the Court of Appeals, which found that the union in the employment practices had consistently and egregiously violated the Civil Rights Act and ordered a goal. In 1982, there was a contempt citation. 83, a second contempt citation. The discriminators were found guilty of contempt. In 1986, the United States Supreme Court upheld the contempt citation, noting a standard of persistent and egregious discrimination, and found intentional discrimination. And the EEOC took a position that there should be an award of relief only to the actual victims of unlawful discrimination. Now, given the background of what had happened, it is clear that the future would have held more discrimination for the black workers there. And in setting a goal, the court was putting the employers on notice that they had to move toward hiring blacks. And it was a flexible goal, and the timetables had been extended. So that, given the history, it was pretty plain that in the future there would be discrimination against specific individuals. And when you dealt with a base of about 3%, it was plain that there had to be more blacks qualified. Whether you could get to a higher number, what number you could get to was uncertain. But wasn't that remedy reasonably calculated in a remedial sense to prevent discrimination against specific blacks in a context where it was obvious that that would happen, and in a context where there would be blacks at least equal to, if not superior to, some of the whites who would be competing for the same jobs?
Senator, since you mentioned that in our last round, and that you would come back to it, I tried to give that some thought, and what the context of that case was, as you know, one among many of those cases involving this difficult area of relief to non-victims of discrimination during the 80s. And the Supreme Court was going back and forth. I believe that this case occurred after cases such as Stotts, in which the Supreme Court limited relief indicated that relief should not go to non-victims. With that said, and with it noted that, as I indicated to you in my prior testimony, that this is an issue that reasonable people have disagreed on. That I think that people who are well-intentioned all want to make sure that you do all to include individuals who have been excluded, but at the same time not violate the sense of fairness that's in the statute. In this particular case, and this is more of an intramural concern at EEOC and the way that the agency operated, at the lower court level, the general counsel, which is quasi-independent, and we respected that independence, had already been given the authority to litigate the case, so that when it was appealed to the Supreme Court, there was to my knowledge, no additional vote of the commissioners needed. That decision was made between our general counsel, who's already been authorized to litigate the case, and the Solicitor General. The argument, as I remembered, was consistent by the Solicitor with what you said, but I'll add this point. Independent of our processes and as an individual, in reflecting on this, I do recollect urging the Solicitor to argue for contempt proceedings in this case in the brief, and that there be sanctions brought against such an egregious violation of a court order. That was consistent with the approach that I think I attempted to outline in some of not only my speeches but in some of my other writings, that when there was a violation of the anti-discrimination laws or a court order that was in place to resolve it, that the appropriate response should not be on the numerical approach, but rather that the appropriate response should be for the court to use its powers, its inherent powers, to force compliance.
Well, Judge Thomas, I quite agree with you that reasonable men can differ on these issues. And I think that's one of the good features about your participation in this field, because you have been able to advocate positions as a black American which had unique standing. And when you're against affirmative action, that has special significance because of your unique background. You have affirmative action having been sanctioned on all sides by the National Association of Manufacturers, by the liberals on one side and the conservatives on the other. When you talk about contempt citations, I agree with you, but it is very hard, and I've had experience in the law enforcement field, to deter people or to penalize them enough to really get the job done to materially affect their future conduct. So that brings us back to the remedy of establishing a flexible goal, which at one time you had agreed with. Now, you've just repeated the position you've taken consistently, and that is that there should not be relief to non-victims. But my question to you goes to the likelihood of future victims. In a context where blacks have been egregiously discriminated against, it is clear that that's going to happen in the future under the same circumstances. And the way to prevent future victims is to set the goal. And my question to you is, isn't that a reasonable course which the federal court followed and the Supreme Court upheld? And, of course, you disagreed with.
It is certainly the course that the Supreme Court has upheld, and I disagree with that as certainly a policymaker. The point that I have made that underscored this, and it has to be kept in the context, and I've argued for it. It seems as though only one side of the equation is finds itself into in the debate oftentimes. I felt as a policymaker that the best way to enforce the law, to enforce anti-discrimination laws, is to increase the remedy, the direct remedy for discrimination.
Only way?
I think that the first, my view would be, and my view was, that the first step should have been that the relief under Title VII should have been much stronger.
Well, when you say relief, you mean the sanction, the contempt citation, the fine, or the penalty. But should that be the only relief? Where you have a remedy which is directed to secure the employment of blacks who may be predicted with reasonable certainty are going to be actual victims, why not? Why not protect their rights where you have virtually certain grounds to conclude that they are going to be the next victims? And the remedy is directed to future victims to secure the employment.
First of all, during my tenure at EEOC, Senator, regardless of what my own concerns were, we did approve and did use goals and timetables in instances in which we felt they were appropriate. And the General Counsel had developed, and the Commission adopted, I believe, if not used, on a specific policy on goals and timetables. But there are other approaches. One of the things that I thought was appropriate, let's just talk about the case where you're saying making sure we know that these employers are not going to do what they should do. I felt very strongly that EEOC should have been, and we did become more intrusive in their personnel matters. That is, that it's one thing to say, well, we're going to have goals and timetables, and there's no monitoring. You don't make sure that they're doing specific things to achieve specific goals. We made sure that there was specific conduct required, and EEOC monitored to determine whether or not that specific conduct was in fact taking place or being engaged in. I think that that's an appropriate way, and we've talked earlier in these hearings about outreach and recruitment, etc. But I felt that we could be much stronger with a combination of monitoring and a combination of specific activities. And again, I underscore that with saying that we did use goals and timetables.
Well, I understand the variety of other processes, but it just seemed to me in the context of that New York case where you knew that there would be future discrimination, the remedy was very carefully tailored, that was an alternative which would be reasonable to use. Well, let me move on to the question of, Mr. Chairman, you have asked about the vote being on and my preference perhaps this is as good a time to break, since we must break as any, to vote and return.
There's about 10 minutes for us to be able to get over to the floor and vote. And the senator has about roughly 15 minutes left in his questioning. So I think it may be appropriate to take a break now, and then you can decide whether you want to break after this as well. But why don't we recess for, it'll probably take us 12 to 15 minutes before we go over and back.
As you have moved in favor of flexible standards and goals to being against it, against the backdrop of the decided cases, and I'd asked you about the pros and cons on having a remedy for a category which I classified as affirmative action for future certain discrimination victims, which I think was the fact under the New York case. And let me move now to another category. And regrettably, there's not a great deal of time to cover a matter of this importance, where I think the American people really need to know what's going on, and I think there's no better person to tell them than you, sir, with your background. To a category of what I would denominate as affirmative action for previous discrimination victims in another context, where that person has the potential or apparent potential for being as good as, if not better, than the person displaced. And I want to come to the Yale Law School admission, and not to personalize it with you, but to take Professor Stephen Carter, who's an African-American distinguished professor now at Yale, Yale being a very good law school. And Professor Carter has just written a book, Affirmative Action Baby, and he says flat out that he enjoyed the benefits of racial preference. And let's assume, although it may not apply to Professor Carter, that somebody who comes to Yale, an African American, product of inferior elementary school, high school, college, but has the potential, why shouldn't Yale give a preference? And you, in your testimony, in response to my question, oppose a preference. But why shouldn't a law school like Yale give a preference to give that person an opportunity to blossom fully, even though on the test scores at the moment that African American doesn't measure up quite to the white person he's displaced?
Senator, I guess the difference that we have there is perhaps semantics, but let me explain to you what I have supported and what we argued for when I was in school. And that was that schools like Yale or other schools across the country should look at how far a person has come as a part of a total person. That you can look at kids who had gone to elite schools or had the finest family background and professional parents, or you could take a kid from the inner city who did not have all those advantages but had done very, very well, and assess whether, one, this is the fact that this kid has done so well against the odds, is that an indication of what kind of person this is or how good that kid can be? Is that an indication of how much drive that person has, how much stick-to-itivity that person has? I think that during that era, those of us who were then the beneficiaries of what were called preferential treatment programs, I think that was the exact terminology then. It was an effort to determine whether kids had been disadvantaged, had socioeconomic disadvantages, had done very, very well in other endeavors against those odds. And I think that the law schools, that the colleges involved attempted to determine, are these kids with all those disadvantages qualified to compete with these kids who have had all the advantages? That's a difficult subjective determination, but I thought that it was one that was appropriately made. One of the aspects of that is that the kid could come from any background of disadvantage. The kid could be a white kid from Appalachia, could be a Cajun from Louisiana, or it could be a black kid or a Hispanic kid from the inner cities or from the barrios. But I defended that sort of a program then, and I would defend it today.
Well, Judge Thomas, what you're just saying, though, is a preference. Implicit, if I understand you correctly, is the factor that the kid, as you put him, has come a long way, does not at that precise moment going into Yale have as good a record as another person. Take an African American who's come a long way, come from a disadvantaged circumstance. At the moment of critical judgment, that African American, does not have as good a record as a white student, but would you then give him the preference? Do I understand you correctly?
What I've said is that kid, particularly with the socioeconomic background, I think the law school, we all make that determination. How much drive does this person have? You know, you hear the, in playing sports, sometimes you hear coaches talk about it's not the size of the dog, it's the size of the fight in the dog. I think that the point that I'm attempting to make is that Yale or other schools try to make that subjective determination about the total person. And I thought that that was appropriate. And I think there are other individuals like myself, when we hire, we look for more than just the person who's had all the advantages. We look for people who've had some of the disadvantages and have overcome those odds. I think it's very important.
Well, Judge, I hear you very close to my position, but what I believe I'm hearing is that you're in favor of affirmative action preference, at least in that context.
That's, and I think I have said that.
Well, I hadn't understood it from all your writings.
I have.
30 seconds, because I'm confused.
It's going to destroy a 5-minute train, Mr. Chairman, but go ahead.
Is that constitutional?
I have not, Senator, I have not looked at it in that context. I assume that it was good policy to help to include others, and I have not looked at it in that context, Senator.
Mr. Chairman, it'll only take me 4 minutes to get back on my train of thought. If a preference there, Judge Thomas, if a preference there for the disadvantaged kid, as you put him, has come a long way, but who can't quite measure up at that moment, why not a preference in employment?
And I think that, again, Senator, I have looked at education as a chance to become prepared. I have, in my thinking personally, and I'm talking totally from a policy standpoint, that education was that chance to be prepared to go on in life. It was an opportunity to gain opportunities. For example, when we have our programs, even the ones that I established at EEOC, the effort was to give training, to bring kids in, to bring individuals in and give them an opportunity to prepare themselves. Not in a way that I thought was offensive or in a way that was strictly based on race, but rather based on a number of criteria, a number of factors, including how far that person had come. I think that that is important, and I think that you can measure a person by how far that person has come and by what that person has overcome to get there.
Judge Thomas, that's fine for those of us who have gone to Yale, but what about the African American youngster who doesn't have an educational background and is fighting for a job? And you have a case like Crossan versus Richmond, which upset a minority set-aside. And after that happened, the Philadelphia plan was one of the first in the country to move ahead with affirmative action. You should see the figures taking an immediate nosedive in African American young people, so that if you have a Judge Thomas or a Professor Carter who come to the Yale Law School in that context, that's fine for their next step ahead. But if you have someone who's a 10th grade dropout and is struggling to get a job in a trade union in Philadelphia or New York in the case we talked about, why not give that person a preference because of the discrimination which has affected that person in his schooling, where that person has the potential to be ultimately as good as, if not better than, the white applicant whom he displaces.
Senator, of course, you do have the question that I have indicated, and I don't think that the cases necessarily break down that way. They don't make the distinction subjectively that way. I believe it just strictly says, it doesn't say that this kid has to come from a disadvantaged background. It doesn't say that the kid has to have had problems in life. It's race specific. And I think we all know that all disadvantaged people aren't black and all black people aren't disadvantaged. The question is whether or not you are going to pinpoint your policy on people with disadvantages, or are you simply going to do it by race? That is a difficult question. I was the first to admit that. It's one that needed constructive debate and discussion. But I don't think that there is a person in this country who cares more about what happens to kids who are left out. What I have tried to offer and what I have tried to say from the first days I entered the executive branch was that we need to look at all avenues of inclusion. You talk about education. In this day and age of mandatory education up to the 12th grade, I think we should ask ourselves the rhetorical question, why is it that a kid who completes 12 years of mandatory education can't function in our society? That is particularly detrimental to minorities. We know it. And we know that there is a tremendous correlation between education and the ability to live well in this society, as well as to be employed and to have a good life in this society.
Judge Thomas, I accept and applaud your sincerity. And I agree that there are disadvantaged people who are not, and minorities. But focusing on minorities for just a moment, because that's the central problem. When you talk about the lack of educational opportunity for African Americans, it's true across this country. And that's why it seems to me that the logic that you accept on a preference to get into the Yale Law School ought to be applied as a preference to get a job in New York City, where the local discriminated, or in Philadelphia, where the Philadelphia plan had been put into operation, where there is good reason to conclude that that person has the potential to succeed. Judge Thomas, have you seen this very recent report by the United States Department of Labor on the glass ceiling?
I've heard of it. I haven't seen much beyond my backyard in the last 70 days.
Well, it's a stark picture about minorities and women holding less than 5% of managerial positions. And one conclusion, to put it plainly, the glass ceiling existed at a much lower level than first thought. And I would turn to one critical line from Professor Carter's book, which I think really puts in a nutshell much of this affirmative action debate, when he says the reason for the search is to find the blacks among the best, not the best among the blacks. And that if you have the affirmative action, as you concur on preference at law school, then the potential is developed to a Professor Carter or a Judge Thomas. And I would submit to you that if you give the struggling, disadvantaged high school dropout who's African American a preference because of the collateral past discrimination and the high likelihood that he's going to be a victim of future discrimination, that it makes sense.
Well, what I have said, and I don't know, I think it's easy to point out conflicts and to draw very sharp lines, but let me make a couple of points, Senator, if you don't mind. I have been an aggressive advocate of giving minorities the opportunity and the occasion to develop potential. We have done that. I've done that as the head of an agency, as well as my own approaches in my personal life. I think it's critical. And I've heard the same arguments for most of my adult life, and we have, of course, many of the same problems. With respect to the existence, the current existence of those problems, we attempted, when I first arrived at EEOC in 1983, to point that out in a project that we called Project 2000. What would the work environment look like? Where would minorities be? Where would women be? What would some of the problems be? I think some of what the Department of Labor did later on involved similar approaches. That was an expression of our concern about what was happening in the educational arena. When I was at the Office for Civil Rights, I think it was clear to us then that there were going to be problems in the future because of the minority participation in education. And I think we're beginning to see evidence of those problems. There is at every level we could begin to attack these problems. I have been concerned about it from a policy standpoint, and I've spent my adult life being concerned about it as on a personal level.
Well, you talk about your position in 1983. Judge Thomas, you were in favor then of goals and flexible goals and timetables. Perhaps you will be again. The great advantage of Judge Thomas or Professor Carter is a role model. And I think that's one of the aspects which speaks very well for your current position and is a big boost for the Supreme Court of the United States. And there's a good bit of politics at all levels of this proceeding, but one level of the politics which you wrote about in a speech back on April 25th of 1988, complaining that the liberals play with the ill treatment of the blacks and give them giveaway programs, and your point that blacks will move toward a conservative line. And you may well be a role model which will attract many, many blacks to the cause of conservatism and to the Republican Party. And that's something that you and I discussed back in 1984 after the re-election of President Reagan. You had made a speech that the Republican Party did not reach out for blacks. And I picked up the phone, you and I had lunch and had a program to bring blacks into the Republican Party. We didn't do very much, so I called you again a year later. We still haven't done very much, but we may do something now. But I think that is I'm as stated, considering your nomination, and I'm undecided and want to hear all the witnesses. And I'm not going to vote for you for help in bringing blacks into the Republican Party. My support would be based solely on your qualifications. But I think a collateral consideration might well be the benefit of seeing an African American with a different line of thought as a role model. Let me move on to Rust versus Sullivan, which Senator Leahy took up, but I want to approach it from a little different angle. And the question that I have, Judge Thomas, turns on the change in the agency regulation. And you approved that principle in the speech you gave earlier this year at Creighton University on February 14th. And I have a concern about shifts in regulations where the Congress has let them stand. Very much in my first round, as I expressed a very substantial concern about disregarding congressional intent and having later Supreme Court decisions like Ward's Cove reverse cases like Riggs. And the background of the controversy arises from federal statute which says that no funds shall be used where abortion is a method of family planning. But a regulation was issued in 1971 which said there could be counseling. Then in 1988, 17 years later, the Secretary of Health changes that. And in your speech at Creighton University, you agree with Justice Scalia that agencies should be able to change their regulations, and you make reference to political accountability in a somewhat different context, but I think the political accountability is important. And then the Supreme Court, in Rust versus Sullivan, says that the Secretary can change the position when the new regulations are more in keeping with the statute's original intent, are justified by client experience under the prior policy, and accord with the shift in attitude against the elimination of unborn children by abortion. Now, without respect to the abortion issue, I have a grave concern about a shift in regulation based on political considerations, which you appear to sanction in your Creighton speech, and a very deep concern about the Supreme Court upholding a change in regulation because they accord with the shift in attitude. When Congress passes a law, no funds may be used for family planning where abortion is involved. No procedure where abortion is used for family planning is acceptable. But that does not preclude counseling or the exercise of freedom of speech. It stands for 17 years. What is the justification for changing what Congress has ordained, congressional intent which has stood, because there's a shift in attitude or some political change of wind?
With respect, Senator, to the change in regulations, I think that what I pointed to in the Creighton speech was the line of cases beginning, I think, with Chevron, which involved the change in regulations and whether or not the agency could make those changes. That's the controlling Supreme Court case with respect to the court's deference to the agencies when reviewing their regulations. And the point that I was making about accountability is that this body, in its relationship with those agencies, could change the rules for them. And I assume that that's the kind of accountability that the Supreme Court was referring to. I don't know. But if you note in that speech also, I took issue with the sense that this deference to agency can continue to be expanded and be unlimited. That was a concern because at some point you would defer so greatly to the agency, even when the court thinks it's moving away from the intent of Congress, that there is no judicial review. So the question became, what are the limits of that? But of course, in deciding our cases, we would follow the lead case, Chevron, which, as I indicated, permits changes in regs. My concern would be the similar concern that I expressed earlier here. And I think that when you engage in judicial review in administrative law, this would be the same concern, and it would be actually the bottom line or the baseline of analysis in those cases. Is the agency's interpretation a reasonable interpretation of congressional intent? That is the important line to draw, with the reference being, as it is in statutory analysis, what is the intent of Congress? If Congress changes that intent, then the agency, of course, can't go beyond that. If Congress is explicit about that intent, then the agency has very, very little room within which to maneuver. If it's broad, of course, the agency may be able to engage in a significant range of reasonable conduct and choosing of options. That was the point that I was trying to make in the Creighton speech. But the bottom line for us, the baseline, the anchor in the administrative law cases is always what is the intent of Congress, and is this a reasonable interpretation of that intent, whether we agree with the policy of the agency or not, or the change in the agency's policy or not.
My time is up. I'll return to that in the next round. Thank you very much, Judge Thomas, and thank you, Mr. Chairman.
Before I yield to the senator from Alabama, a point of clarification. Did you say, Judge, that affirmative action preference programs are all right as long as they're not based on race?
I said that from a policy standpoint, I agreed with affirmative action policies that focused on disadvantaged minorities and disadvantaged individuals in our society.
Well, for example,
I'm not commenting on the legality or the constitutionality. I have not visited from that standpoint, Senator.
Because we all know, I went to one of those state schools. My son went to one of those Ivy schools. I didn't realize in those Ivy schools you all went to, that there are preferences based on whether or not you are what's it called if your father went there? A legacy. If you're a legacy,
or
what part of the
country,
or if you come from a part of the country. So my son might not have gotten into the school because his father didn't go there, even though his marks are higher than the kid who got in. That's how it works, as long as everybody knows that. And if that's not preference, I don't know what is, but I'll come back to that, because I think it seems like preference for whites are okay, but preference for blacks aren't. But let me go to the senator from Alabama.
Judge, just to follow up briefly, it's my information as the chairman of the EEOC that you hired 49 individuals who reported directly to you in the headquarters office. Of these, 26 were women, 53%. 33 were members of minority groups, 67%. And that you hired 29 special and executive assistants, of whom 14 were women, 15 were black, 1 was Hispanic, and 2 were Asian. Did you have a policy of preferences at that time as you were hiring them?
Senator, my policies were as I stated. I looked long and hard to make sure that any number of people, whether they were minorities, women, individuals with disabilities, were included in my search. I always, to the best of my abilities, hired the best qualified people.
All right, so now let me visit just briefly this issue of privacy. You have testified that you find in the word liberty of the 14th Amendment a right of privacy, and that you indicated that that right of privacy extended to the marital relationship. And then to Senator Biden, you testified that you thought that an individual had a right of privacy. Now, are those, I don't want to misquote you or give you anything else, would you clarify exactly your status as to the right of privacy and how it applies particularly to individuals?
The point, I think, the exchange that we had was along this line, that there was a right of privacy as established in Griswold, and that applied to the marital relationship. The question then became, was there a right of privacy that applied to non-married individuals? And the point that I was making was that right of privacy in the intimate relationship was established using equal protection analysis under Eisenstadt v. Baird. And I think that's where we left it.
All right, so now, do you come to the conclusion that the Fifth Amendment contains a right of privacy under the word liberty?
I have not, that's a question that I had not considered, but I don't see where there would be in the analysis. I would parallel the analysis with the 14th Amendment, but again, that's analysis that I don't know of a particular case that has based it on that.
What is your feeling about the incorporation doctrine?
Senator, I certainly have not had in any occasion, and I certainly don't, to object or to criticize the incorporation doctrine. I think the only concern that I've seen that's been raised has to do with individuals who might think that the incorporation doctrine limits, I think along the lines perhaps of Justice Black, would be the limit of rights that individuals have.
Would you have some question with the selectivity of the President of Black's incorporation doctrine?
The exclusivity of it.
Now, under the Constitution, I don't think there's any question that there is a right to life in the 14th Amendment, 5th Amendment, and may well be that that one of the purposes of government is to protect life. Now, I think we've found that the right to life is not absolute, and that there's questions as to whether or not the right of privacy would be absolute. The right to life, you have the death penalty, for example, which is a limit. You have to go through the due process of law and other aspects that might be controlling on that. In the event that there is a conflict between two principles of constitutional right, do you have a method or methodology by which you would give a priority to one right over another when there is such a conflict?
Senator, I think that the occasions in which there has been conflicts, or the ones that usually in which there's a right asserted, have to do with the government in some way becoming involved or regulating a particular right. And what the courts have attempted to do, of course, is to determine how to value that right. Is it a fundamental right? And if it is a fundamental right, then of course the state would have to show that it has a compelling interest in some way regulating this particular activity. I think that is important. It's one thing to state what the constitutional analysis is, but I think what it says to us all is that we place a very high value on certain rights that we have, that we consider core fundamental rights in our society. And the state must show a reason that is extraordinary, compelling, overwhelming as to when it decides that it's going to do something that interferes with these rights that we value very highly. So I think that, and that could, of course, can be stated with different degrees of precision, but in the equal protection analysis, that's precisely what we're attempting to do, is to value those rights and to require more of the states. We're not going to defer to what the state is doing simply because it is the government, but rather you must have a reason for doing it.
You've testified several times during this hearing that when you were director of the EEOC, that you felt that the EEOC laws pertaining to discrimination in employment didn't have enough teeth in them. What teeth would you advocate being added to the discrimination in employment rights statutes that give remedies?
Well, I'm not going to, let me answer it in this way, Senator, without being evasive. I know that there's pending legislation before this body in that area, and I don't think I should get involved in that debate. But during my tenure at EEOC, and I think it's a matter of written record, and that I abhor discrimination, and I think that Title VII undervalues the damage done by discrimination in the employment context. I've advocated damages, I've advocated contempts, I've had proceedings, I've advocated penalties. Something that would do more than say to an employer, all you have to do is hire the person that you discriminated against, or pay that person what you would have paid that person. That was my approach to saying, I think, or the country saying, we are serious about the damage done by employment discrimination, at least as serious as we are about other kinds of non-compliance with our civil laws.
Well, you have stated a number of times that you didn't think there was sufficient teeth in those laws. Did you ever make a recommendation in writing or orally as to additional teeth that should be added to the administration? That they ought to look at that from a legislative viewpoint?
I certainly did.
You did?
I did. I can't remember whether I ever reduced it to writing, but it was something, I guess at some point I probably began to sound like a broken record. I advocated in this context, Senator, I felt that we should have had a positive civil rights agenda, a very aggressive civil rights agenda, even if we disagreed as to specific policies. And I felt that adding to and enhancing the sanctions of Title VII could be a significant part of that.
Do you remember any of the specifics that you advocated?
I think they were generally, as I indicated to you, that they should be increased damages, perhaps penalties, and even treble damages. And certainly a use of contempt proceedings where there were violations of court orders.
Treble damages would be punitive damages, then, wouldn't it?
Well, I think discrimination, my view was that discrimination was abhorrent enough to make that appropriate.
All right, so now, let me look a little bit from your life and history. You are somewhat of an enigma. You have gone through many changes in your life, and during the last 3 decades, society in America has gone through many changes. The thinking of individuals evolve. They change with time. You have told us about your background in your opening statement and through testimony here. It's interesting to note that you decided at one time in your life that you wanted to study to be a priest. And you went to seminary, and then to a seminary in Missouri. And in articles that I have read, somewhat from Atlantic Monthly, Warren Williams, and Karen Tumultry of the Los Angeles Times, and others have described your experiences, that you suffered the pangs of racial slurs in the seminary when people would at night in a dormitory say, "Clarence, smile where we can see you." Then I believe there has been recited instances on the death of Martin Luther King and the callous hatred statements that were made by your fellow students relative to that. Would you tell us what happened relative to that instance?
Well, Senator, that was with respect to going to the seminary. Of course, that's always a very, very deeply personal choice. It's a deeply personal religious choice. When you make that decision at 15, there is always opportunity for change and growth and development. The point that I was in my first year of college, though, and beginning to grow and to develop as an adult. I can still remember that afternoon, actually it was in the evening, that one of the students who was walking up the stairs in front of me, whose name I've never revealed and won't, didn't know I was behind him, and someone yelled from the basement, "Martin Luther King's been shot." And he said, without looking behind him to see that I was there, "That's good. I hope the SOB dies." That was the moment, precise moment, that I decided to leave the seminary, and the moment when I began to be involved personally in very much of the marches and participating in changing our society, and left the seminary. The seminary at Conception was in a very, very remote area. It's if you're in the area, it's Conception Junction, Missouri. That's near Savannah, Missouri, near St. Joseph's, Missouri. It's in the northwest corner of Missouri. One would have to really be there or lost to know where you are. You either know where you are, you're definitely lost. But when we went down immediately after that to Kansas City to participate in a number of the marches, and there were other events which I won't get into that occurred that summer that were equally as difficult and touching. And it was at that point that I transferred to and went to Holy Cross College.
Also, I believe you told me in my private conversations with you that that was a influencing this factor that caused you to decide not to become a priest. Is that correct?
It was a deeply influencing factor in that decision and many, many aspects of my life.
Now, of course, part of this shows, I think, shows you do have a sensitivity to the factors that have occurred relative to the movement of progress of race relations, and I think that ought to be brought out in fairness to all parties concerned. Now, you went to Holy Cross. What did you major in Holy Cross?
Well, it's when I transferred to Holy Cross for my sophomore year, and I majored in English literature. And people would ask me why I majored in English literature, and my response has been, and it's accurate, I majored in English as a second language. I simply did not have the capacity to speak and use English at a level that I thought necessary to function in this society. So I decided to major in English. I had been fortunate enough in the seminary to have had Latin, to have had German, and to have had French, which all were helpful in teaching grammar. But I needed English. I needed to be immersed in something that I found painfully difficult. And that was the basis of my major.
What did you minor in?
I think protest.
Protest.
I didn't have a minor, Senator. We had a core requirement. Those were the last years of core requirements where you were required to take specific courses, metaphysics, ethics, philosophy, those sorts of things.
At Holy Cross, of course, you prior to that time had been involved in demonstrations in carrying tumultuous Los Angeles Times article. Describes, it says, in combat boots and army fatigues and sometimes a leather tam of the Black Panthers, Clarence looked the part of the angry radical as he strolled down the campus of Holy Cross College. He opposed the Vietnam War but helped found the College Black Student Union. Thomas's most notable act of defiance came after a 1969 protest against the appearance of a recruiter from General Electric Company, a company that had been heavily involved in the Vietnam War. Thomas was one of a group of black students who believed that blacks had been unfairly singled out and disciplined by campus officials. They walked off, effectively resigned from the college in protest. The protesters didn't wear T-shirts and jeans, but suits and ties. Later, they were granted amnesty and allowed to return. Other articles would indicate that you led a protest against the South African investments of Holy Cross trustees. Is that a description that is fairly accurate of your attitude and your participation in various protests and affairs as of that time?
Senator, I think as I have attempted to indicate over the past few days that I have always been, not always, but throughout my adult life and perhaps since the age of 16 or 17, very much involved and interested in all these issues. When I went to Holy Cross, there was a tremendous amount going on. And one of the areas that was of great concern to me was what I perceived at that age as injustices in our society. And what I attempted to do was to be involved and to protest and be active in protesting what I thought were injustices in a way that's permitted in our society. One of the activities was what we designated in later years, in 1969, the walkout. That is that we felt that some students, minority students, were being unfairly treated. And as I remember it, we did not walk out with the intention of coming back. The walkout was, to my way of thinking, a walkout. It was leaving. And in fact, returning home, the only thing I hadn't figured out was how I was going to face my grandfather. But the other activities that we were involved in included free breakfast programs, tutoring programs, and I think that that's been true throughout. That interest has been the same interest that I've had throughout my life. That has not changed, although I have eschewed the combat boots and the fatigues for suits that I think are overpriced.
In this Los Angeles Times article, it says, today he seems embarrassed about those days. You want to respond? You want to respond to that?
No, I'm no more embarrassed about feeling strongly and passionately about injustice than I am about doing anything else in my life. I think that I would rather have those days of wanting to participate in our political process, even though I've grown and matured, than saying that I spent all my college days drinking beer and having a good time.
Well, in this article, it goes on and says, in a November 1987 interview with Reason magazine, he lamented, "The thing that bothered me when I was in college was that I saw myself rejecting the way of life that got me to where I was. We rejected a very stable and disciplined environment, an environment with very strict rules, an environment that did not preach any kind of reliance on government." You want to comment on that statement?
Well, as I've indicated in these hearings, The environment in which I grew up was a disciplined environment. It was one in which you were expected to be up early. And I can still remember my grandfather on Saturday mornings when he thought we were going to sleep until 7 or 7:30. He would come to the open windows of our bedrooms and just simply say, "Y'all think y'all rich." And that had a way of inspiring you to get up. But it was a disciplined environment. It was one that required a lot of effort. My concern wasn't so much of juxtaposing that environment with the protests that we were engaged in. I thought that that was appropriate. But if you remember that time, it was a protest or a challenging of all authority and all rules that we grew up by. And it was that the question was raised, why should we take metaphysics? Why should we study until 11 or 12 at night? All those questions were raised. And I thought that the thing that the efforts or among the factors that had permitted me, in addition to Holy Cross being so good as to accept me, the things that had permitted me to survive and to do well there was to take advantage, to work and take advantage of those opportunities. Again, as I said earlier, to burn the midnight oil, and that was a part of the past that I saw us beginning to challenge or to question.
Why did you decide to go to law school?
There were a couple of reasons, Senator, that I thought at the time were of major proportion. You know, we wanted all to change the world at that time. And I guess at that age, you think you actually can go out and change the world. I wanted to right some wrongs that I saw in Savannah. Some specific wrongs with respect to my grandfather and what he was able to do with his life, as well as to the overall wrongs that I saw as a child there. And during law school, I did go back in the one summer that I worked for a law firm to Savannah in an effort to do that, and did not decide to return to Savannah, instead went to Missouri. But it was my goal during the entirety, it was my reason for going to law school, and it was my goal until my third year to return to Savannah and practice law.
I started talking about your biographical that you were an enigma, a good deal of uncertainty for changing times and changing. And during these hearings, I think you have maybe surprised some people with your position, for example, on the fact you don't think natural law ought to be used as a method of constitutional adjudication, that you support, in effect, public housing, that you believe that multiple languages ought to be used and we ought not to have English-only approach in governmental activities in schools. You found a right of privacy. You seem to be seem to have an adherence to the present methodology in deciding cases on separation of church and state. You've expressed some ideas that would indicate you believe that the Constitution evolves and develops as issues change, which brings us to the question of what is the real Clarence Thomas like, or what will the real Clarence Thomas do on the Supreme Court if he is confirmed. There's some that believe you're a closet liberal, and some, on the other hand, that believe you are part of the right-wing extreme group. Can you give us any answer as to what the real Clarence Thomas is like today?
Senator, I think that during the past 10 weeks, people have written and formed conclusions about me, and that's gotten to be a part of this process, and I think they're free to do that. But it reminds me of the story that I heard about Judge Hainsworth during his ill-fated nomination and confirmation process, in which he was reading about himself in the morning paper, and having read the story, he looks up and says to his wife, "You know, I don't like this Hainsworth guy either." But
I thought it was otherwise, that his wife said that.
Well, well, either way it works. The point is, though, Senator, that people form conclusions. The one aspect of a lot of the publicity that I did like was that my friends from as far back as my college years, and I mean my friends, not people who claim to be friends, have pointed out the continuity and consistency, the growth and development. That has been one of the most touching aspects and rewarding aspects of the past 10 weeks in reading and hearing. But those conclusions that people form about you were not about me, were not the real Clarence Thomas. I am the real Clarence Thomas, and I've attempted to bring that person here and to show you who he was, not just snippets from speeches or snippets from articles. The person you see is Clarence Thomas. I don't know that I would call myself an enigma. I'm just Clarence Thomas. And I've tried to be fair and tried to be what I said in my opening statement. And I tried to do what my grandfather said, stand up for what I believe in. And there's been that measure of independence. But by and large, the point is I'm just simply different from what people painted me to be. And the person you have before you today is the person who was in those Army fatigues, combat boots, who's grown older, wiser, but no less concerned about the same problems.
I believe my time's up.
Thank you. I think we'll continue to go, and we'll move to Senator Brown, and then we'll break for lunch after Senator Brown finishes.
Thank you, Mr. Chairman. Judge Thomas, I must confess this morning's testimony has helped me understand you a great deal better. Particularly your comment about why you chose English. If I heard it correctly, you said it was because it was painfully difficult for you. It does help me to understand why you'd want to undergo a fifth confirmation hearing, if nothing else. I'm sure you appreciate the reason for this extended confirmation hearing and the multitude of questions. Some have alleged that the Senate is made up of 100 secretaries of state, but I have long thought there was more like 100 justices of the Supreme Court than secretaries of state, and it is obvious that we have a fascination and a continuing interest in the work that you may well take on. Over the course of our hearings, you have declined to indicate how you would rule on specific cases. And clearly that's in line with what both Democrats and Republicans on this committee have indicated is the practice and, in effect, the canons of ethics for judges, to not rule on a case without hearing the facts and listening to it. The media advises us that you had a meeting with the President, however, up at Kennebunkport. And I'm wondering if in your discussions with the President, you took a similar position. Did you decline to discuss with the President or indicate to the President how you would rule on specific cases?
Senator, after I arrived in Kennebunkport somewhat bewildered and not knowing exactly what was going to happen, in fact, not knowing what was going to happen, the President asked me to chat privately with him, and he said that he had two issues that he wanted to discuss. The first was, if you are nominated, will your family be able to sustain or to survive this process? Because it will be a difficult process. Not knowing really what would come, my answer was yes. In retrospect, I might adjust that a little bit. And certainly would have conversed with him more at length about it. The second question that he asked me was, and I think this is almost verbatim, can you call them as you see them? And then he went on to indicate that if he did not agree with me, were I to be confirmed and sit on the Supreme Court, that I would never see him criticizing me in public, even if I disagreed with him or he disagreed with me. And I assured him that I could call them as I saw them, and that I would as honestly as I could and to the best of my abilities. And he indicated that he was going to nominate me at 2 o'clock and suggested that we have lunch.
Since that meeting, have you had any discussions with the President where you've committed how you would vote on a particular case or a particular legal doctrine?
No, Senator.
In other words, you've given the President the same ethical treatment you've given us?
Well, I've tried to be consistent across the board, Senator.
Earlier, Senator Heflin mentioned property rights, and we've discussed a great deal about various theories of protecting property and individual rights. If I understand the cases correctly, our courts protect personal rights like abortion and others with a standard called strict scrutiny. That is, the government has to have a compelling government interest for any restrictions on those rights. But that a different standard applies for the protection of property rights, called the rational basis test, rational relationship test. Protected by requiring some rational relationship between the legitimate, not necessarily compelling, purpose and means chosen to achieve that purpose. At least in my mind, I think there are a number of reasons why this distinction between personal rights and property rights simply doesn't hold water, is artificial. First, it strikes me that the property rights are of obvious concern to the framers of our Constitution. They're named specifically in the Constitution, with explicit references both to contracts and property. Second, I believe that property is simply an extension of personal rights, and vice versa. That to separate them, to assume that they're different somehow, really reflects I think a distorted view of how our society works. And third, that the political and moral values that we all hold dear strike me as dependent upon private property and the freedom to contract. When I first decided to run for the state legislature, I was very dependent on a job. And my boss was a very liberal Democrat who was active in the Democratic Party. If I had lost my income to support my family, if I'd lost my job, I think it would have had a major effect on my freedom of speech and my political rights. And for the courts or this country to pretend that somehow your right to property is inferior or isn't integrated with your personal rights, I think is ignoring the reality of our society. I must say I'm troubled by the artificial distinction that has been discussed. To provide a lower level of protection for property rights, I think endangers personal rights, and perhaps the opposite is true. I raise this because I think that artificial distinction, that difference treatment, the second-class protection that some have advocated, strikes me as a real problem. We talked a lot about a zoning case and the Moore case, to call it to mind. It strikes me that that was as much a violation of the right to use property as it was a violation of the personal rights of the individuals involved. And it seems to me it's an insult to the American people to somehow think that you can protect one without protecting the other, or that there's a second class of rights, even though they're specifically mentioned in the Constitution. Well, I mention that because I want to ask you about that again. Professor Tribe is one who has great credibility, I think, with many members of this committee, and many members have quoted the professor. I thought it'd be worthwhile to quote him in this case on this subject. Here's a quote of what he wrote. The attempt to distinguish between economic rights and personal rights must fail. He later wrote, it will not do to draw a bright line between economic and civil liberties, or between property and personal rights. As Justice Stewart observed, the dichotomy is a false one. Property does not have rights. People have rights. In fact, a fundamental interdependence exists between personal rights to liberty and the personal right to property. That right and property are basic civil rights. The rights and property are basic civil rights, has long been recognized. The question, I guess, Judge, is this. Do you find, laid out in our Constitution, language that calls for a second-class level of protection for property rights?
Senator, I think that we've certainly, as we have discussed in these hearings, I've said in my own writings that there should be a recognition of property rights and economic rights. And I was talking in that case more about my grandfather and his ability to, as you say, earn his living, not be denied that. But I think what the courts have done in the regulation of the social and economic affairs of our country has been, and I think appropriately so, as I've noted, I have no quarrel with the equal protection analysis that the court uses. The court has tried to defer to the decision of the legislature. In other words, that the balances should be struck by this body or by the political branches, and not second-guessed by the courts. I have no reason to quarrel with that approach. It recognizes that the considerations are very complex and involve any number of factors that are best left to the legislative branch.
In relation to the comments by Professor Tribe, and by phrasing it this way, I'm not suggesting that I want you to become an adherent of the good professor. But on this subject, thinking about the comments of Professor Tribe and Justice Stewart, when they conclude that the dichotomy between personal rights and property rights is a false one, would you agree with that? Do you find yourself in agreement with that? Do you have any observations about that?
Senator, I think certainly I have not re-examined that or looked at that as a judge. And it would require me to sit here and attempt to formulate an opinion on that. Of course, I think we all at bottom feel strongly that we should have the freedom to work and to support our families, or to provide a part of the support for our families and for ourselves. And we certainly don't feel that that's one of the reasons why this body passed Title VII of the Civil Rights Act of 1964 and made those difficult choices. But it's also reasons why you protect individuals in the workforce so that they are not harmed in a variety of ways by the conduct of their employer or the environment itself. I think that those are complicated decisions. We value our ability to own property and to engage in work, but there is a balancing that must take place, and I think that the courts have appropriately chosen to defer to the Congress or to the legislature, the political branches, in making those balances.
Well, I appreciate that comment. I must say, from my own point of view, at least my judgment in society, those that are extremely wealthy don't have to worry about this very much. They've got theirs. But a right to work and save and have an opportunity to keep a fair share of what you produce in this world is darn important to somebody who starts off in life without much, because it's one of the ways they go from the bottom to the top. And I would hate to think in this country that we would assign second-class treatment to someone's ability to go from the bottom to the top, to acquire property, to save, to reinvest, to have a chance to protect the things that they produce for themselves. And I, for one, think a distinction, an artificial distinction between those rights misses the whole point and perhaps jeopardizes that fundamental ability to be a mobile society, to move up. A couple other areas that I want to invite you to comment on. And I appreciate that these are areas that the court may take up. But if you have observations you'd care to make, I would like to have them on the record. The Interstate Commerce Clause is one that has critical impact in terms of Congress and its ability to direct the states and others in this society. Over the years, we've had a wide variety of decisions regarding the extent of the Interstate Commerce Clause. One of the landmark cases in the early 40s basically indicated almost anything we do in any way can affect interstate commerce. I'd be interested in your view of the Interstate Commerce Clause and how philosophically you would approach the questions that deal with it.
I think that you're right in the sense that the court has read those provisions rather broadly, but I make this point and I underscore that by saying I don't have any objection or basis to object, or at this point any quarrel with the way that the court has interpreted the Interstate Commerce Clause. But I make this point, and I've heard some academic objections from time to time, but I can remember reading, I believe, the Heart of Atlanta motel case on which challenged, I believe, the accommodations provisions in the Civil Rights Act of 1964, which is based on the interstate commerce powers. And one of the factors that was used there was that blacks who traveled across the country were impeded from traveling because of the lack of accommodations. And what that brought to mind was that when I was a kid and we would travel occasionally, I think 2 or 3 times during my childhood, by highway from Savannah to New York, that my grandfather would go through this long exercise of making sure that the car was working perfectly, that you had new tires, that we had a trunk full of food, etc., because there were no accommodations. And should you break down, you would be met with hostilities. That was the reality. And so there was indeed some, I would consider, significant impediment on the ability of us to travel, and certainly by extension on the flow of commerce or travel in our society. I have no quarrel, Senator, with the approach that the court has taken, and certainly have had no opportunity to review all of the cases.
Thank you. The Ninth Amendment has come up a great deal in the hearing, and I think continues to be an evolving area of the law. Some have viewed the Ninth Amendment as providing a limitation on the powers of the federal government over the individual. Others have viewed the Ninth Amendment as a provision that in effect mandates governmental activity of a certain nature. Would you share with us your thoughts on that particular amendment?
Senator, as I have indicated earlier, I think that whatever we do with open-ended provisions such as the Ninth Amendment, that we make sure as judges that those decisions are fettered to analysis or something other than our own predilections or our own views. That would be the concern, a generic concern, as I've said before, with any of the open-ended or more open-ended provisions. There has been, the court, to my knowledge, has not used the Ninth Amendment, a majority of the court, to decide a particular case. And there has been debate about what the purpose of the Ninth Amendment is. There could be a time when there could be an asserted right under the Ninth Amendment that would come before the court in which there could be found to be a basis for that right in the Ninth Amendment. I don't know. But as scholars do more work, and certainly as individuals begin to assert rights and the court begins to consider those, I wouldn't foreclose that from occurring.
Thank you. One last question, if I may. I think we're still right on time. Been a great deal of discussion about antitrust policy in the last several decades. I end up viewing antitrust policy as essential for helping guarantee a competitive economy. It's one of the features about America that is somewhat unique. While many other countries have sanctioned monopolies, sanctioned conglomerate, control over the markets, the U.S. has really been a pace setter in demanding that we have competition within our marketplace. There have been many challenges to those concepts of antitrust statutes in recent years. I can appreciate that you don't want to deal with specific cases, but I would be interested in your view of the antitrust concepts and any remarks you'd like to make about their merit.
Senator, my grandfather was a small business person. One oil truck, an ice truck, and a vacuum cleaner to clean stoves, and two little kids to run with him and also to help answer phones. I think that competition in the private sector is healthy in our society. It's healthy not only from the standpoint of the businesses themselves, particularly the smaller businesses, but it's also healthy from the standpoint of products, quality of products that are brought to consumers, as well as prices. And I think that our economy and our country expands and provides opportunities to absorb individuals who otherwise would not have a chance. It is one that it's very interesting after growing up in a household where there is a small business, literally not a separate office, it's the house. You get the feeling of how important it is to have this opportunity to be a part of this competition and to not be foreclosed by certain individuals monopolizing an entire area. So just as reacting as a person, I think that it is important that we have healthy competition in the economic arena.
Thank you, Mr. Chairman. I yield back.
Thank you very much. We will, it's 20 minutes at 1 now. Do you want to keep going? Well, actually, I think what we should do is we should break for lunch, and let's come back at 1:45. Okay. Recess to 1:45.
Right now, you'll be seeing some room shots momentarily of the Senate Judiciary Committee where it's meeting in room 325 of the Russell Building. That's the caucus room. One of the more historic sites on Capitol Hill. 5:30 p.m. They're running right now about 5 minutes late.
Sitting in judgment on a case involving Danforth. And is this conflict of interest? Shouldn't he have disqualified himself? This is what a couple of people this morning, as well as yesterday, have tried to ask about. So far, either inadvertently or on purpose, I don't know, but we've been avoiding that. I'd like to know, too.
Well, I tell you, I'm going to let you go because the hearing is about to start, and I can tell you it is inadvertent. The buttons here on the phones are very sensitive. But we will now go live to the caucus room, which is room 325.
Colleagues who have not had a second round yet from Illinois and Wisconsin have been gracious enough to yield to him for a third round, or part of a third round, so that we can try to meet the twin obligations. Just as the court always has to balance things, Judge, we're having to balance needs here. We're going to apply a strict scrutiny test after Senator Simpson asks his questions to determine whether he meant it. But anyway, all kidding aside, the chair recognizes Senator Simpson, and then we will go in order Illinois and Wisconsin.
Mr. Chairman, I do very much appreciate that. I do have to catch a plane. There are others, and you've accommodated us all on both sides of the aisle, but particularly my friend Paul Simon and Herb Cole. I appreciate that very much, and I really intend to just do 2 minutes, and then that will conclude my activities, and thank you for your courtesies on that. And my remarks I wanted to share with, I think the committee would be interested. I became so intrigued as to the EEOC issue that I went down to the EEOC. I had seen our colleague from Missouri go there. I don't know how many of my colleagues on the committee have paid a visit to the EEOC, but I made it a point to do that about 6 weeks ago. And I spent a couple hours there at the agency's offices on 18th Street, speaking with their employees about the effects and the results of Clarence Thomas's tenure at that organization. I visited with employees who were black, white, Hispanic. I spoke with persons who were handicapped, old and young. I spoke with employees holding jobs from that of manager to maintenance man. Some had worked for both Eleanor Holmes Norton and Clarence Thomas. Some had been there for many years, Eleanor Holmes Norton and Clarence Thomas. Some had been there for many years, while others had come during his tenure. And I was stunned as I looked at my notes from what those people said that day about Clarence Thomas. From just plain, he did a hell of a good job, to things like we're a lot better agency than we were when he came. We came further in his 8 years than we did in the previous 18. I'm quoting now. We feel proud now. Many of us didn't used to. He may have opposed affirmative action goals and timetables, but told us that his personal philosophy and that we were to follow the letter of the law. And then they did, and they cleaned up the backlog. A quote: from the time I got here until he left, I never saw Clarence Thomas try to influence the way a case was being handled. His honesty and integrity are what inspired me. Clarence Thomas's way was, you follow the law. Another lady, in this instance, Clarence Thomas believed in rewarding good work. And Hilda Rodriguez said, Clarence Thomas told us that we were the EEOC and that he was not, that he was just a short-timer. And one other person said, we feared for our jobs when he came, but I felt very proud about working for him after he came. And before Clarence Thomas came here, you could just not move forward. On his last day, one of the employees followed him out crying. Another person over the last decade, this agency has gone from mediocre to one of the government's premier agencies. We've earned that reputation, but Clarence led us there. And the problem now is that other agencies hire away our good employees. And one attorney said to me, when I told Clarence Thomas about the lapses in the age discrimination cases, he said, that's nearly as bad as a lawyer dropping his client's case. And he personally told Senator Melcher about the lapses. However, the attorney pointed out that less than 1% of all cases had lapsed. A handyman who went to work there in '84 told me about a problem he had with his daughter, and now he could walk right into Clarence Thomas's office and talk to him about that. And that's what he said. Another employee told me that, quote, he is the kind of person I would like to have decide if I ever go before a judge. He listens, keeps an open mind, and makes a decision based on reason. I was told that when he left on his last day, he went down from his upper floor office to the ground floor to leave. Every foyer on every floor was filled with people. No one was out drumming that up. The employees were doing this. And these employees made an effort to have the building named after him, but they found they couldn't do that because the government didn't own the building. However, the employees purchased with their own funds and put up a plaque in the lobby. I've never seen that in any building because it's really it's almost corny in Washington, D.C. that could happen. That's something out of one of those old black and white movies. And the plaque says, Clarence Thomas, chairman of the U.S. Equal Employment Opportunity Commission, May 17th of '82 through March 8th of 1990, is honored here by the Commission and its employees with this expression of our respect and profound appreciation for his dedicated leadership exemplified by his personal integrity and unwavering commitment to freedom, justice, and equality of opportunity and to the highest standards of government. Well, those are the folks from all walks of life who worked with Clarence Thomas during his 8 years at the EEOC. And I think it's very important that we hear those who know Clarence Thomas best and what they have to say about him. And it came to me when Senator Leahy this morning noted that we shouldn't ask or expect answers to questions about how you might rule in specific cases. I do greatly concur, obviously, with that. But Senator Leahy also noted that we need to know, quote, how you think, your background, your integrity and impartiality, what kind of a judge you will be. And I agree with that evermore. So I just wanted to share with the committee as to how the people that worked with you felt about you. I think to a politician, it's like the moment of truth, and that is, how many votes do you get in your home precinct? I always like to look at that when I see people here in this place. I always go back and go into their state record and see how many votes they got in their home precinct. Gives you a better idea of how they do and how they operate. So among those that know you best, those are the things that I wanted to share. Integrity, impartiality, and my question, and I'm going to conclude here, and you wrote, or you were interviewed for an article by Sarah J. Davidson. Do you recall that article titled Clarence Thomas, the Pragmatic Chairman of EEOC?
Senator, I don't recall specifically the interview, but I know the name.
You were asked a question by that lady in her journalistic pursuit. Her question was, how do you think that history will record your achievements? Do you recall that question?
I don't recall the question, Senator.
Ooh, you should, because you gave quite a glowing answer to it. You don't remember the answer to it either.
It's probably still the same answer.
Well, let me give it to you, and then I'm going to leave. Get on the plane and skip out of here. You were asked the question, how do you think that history will record your achievements? Well, you say, I just hope that whatever is said, whether someone agrees with me or disagrees with me, they don't waste a whole lot of time on nonsensical things like where I went to school and where I've worked and what I did before I came here, simply bottom line after everything is said, to hope that at least they say, this was somebody who tried to do what was right. That's all. They don't have to say anything else. Just that in his lifetime, when he came to this agency, he tried to do what was right and did not try to play politics and did not succumb to pressure from various interest groups or politicians. He just took a mandate, took a job, and tried to do what was right, unquote. And that was your response to that lady's question. So it was, and I wanted to report that very moving trip to the EEOC, and I'd really have no questions. And I thank you for your courtesies, and thank especially my colleagues, Paul and Herb, for their, Senator Simon and Senator Cole for their courtesies. And thank you, Mr. Chairman.
Thank you very much, Senator. Have you answered the question?
Thank you, Senator.
No, Senator Simon.
Thank you, Mr. Chairman. One of the questions that we face is what really makes Judge Thomas tick. That's really what Senator Heflin's questions were approaching. When you told the story about Judge Hainsworth saying to his wife, I don't like this Judge Hainsworth guy. If we were to vote in this committee on whether we like this Clarence Thomas guy, it would be unanimous that we like Clarence Thomas. That's not the question that we have to face. It is where you're going. When you told about being a student at Holy Cross, I would feel comfortable voting for that student for the Supreme Court. And then in describing yourself, you said, then we thought we really could change the world, making it past tense. Some of us still think we can change the world. Maybe not in huge, giant steps, but in little steps. And you're going to a place where you are going to change the world for a lot of people. People in the Supreme Court who voted for Dred Scott changed the world. People who voted for Plessy versus Ferguson changed the world for a lot of people. People who voted in the Brown decision, Roe v. Wade, changed the world. Members of the Supreme Court who voted on the Croson decision that Senator Specter referred to, the set-aside, the Richmond decision, have denied the right, the opportunity for a great many people. They've changed the world for a lot of people. The Ward's Cove decision changed the world for a lot of people. People of, again, quoting Senator Specter, that 10th grade dropout. And that's, I guess, the person that I'm concerned about. Frankly, a person with Clarence Thomas's ability is going to make out all right. Whether you get confirmed or not confirmed, you're going to do very well. That 10th grade dropout may not do well. We all bring something of a philosophy to our jobs. And Senator Simpson perhaps partially answered this question with his quotation from that interview, the bottom line. But what is the political philosophy, what is the judicial philosophy you bring to the United States Supreme Court?
Senator, when I spoke earlier about changing the world, I think I would distinguish between the way that as a youth you feel that you can go out and take on everything tomorrow morning and get it all accomplished tomorrow morning. At some point, I think you realize that you have to take a step back and begin to approach it more, not so much in a rush or impatiently, but persistently. And if there was one lesson that I learned during that period was the difference between impatience and persistence, the difference between being upset and being committed to something. So today I didn't suggest or mean to suggest by using the past tense that we felt that we could make a difference, that or that we could change the world, that we can't do that today or have an impact today. I indicated earlier that I felt that if I were confirmed by this body and were fortunate to be on the Supreme Court, that I could make a difference. And I also indicated that the same person that was at Holy Cross with the same feelings, a little older and a little wiser, is sitting before you. There was a time when in law school, and I was asked why I went to law school, but there was a time actually before I went to law school that I didn't think there was any reason to go to law school. There was no further reason to prepare, to be ready to make some of the changes in society. There was a time when many of us didn't feel that working through the system, as we called it, was worthwhile. So at some point we had to make the decision that if we prepared ourselves, and as Abraham Lincoln said, I paraphrase it, I will prepare myself, and when the time comes I will be ready. What will you be ready for? I don't know exactly, or didn't know. With respect to my own approach, though, I tried to be persistent about preparing to make a difference. As far as overall philosophy, Senator, as a judge, I think that the approach that I have taken has been one of starting with the legislation or the document before me. It's been one to arrive at the intent of this body in statutory construction, and certainly in broader analysis to not certainly impose my own point of view, but to be honest and intellectually honest and honest as a person in doing my job. I have done that. But there's something that you point to also that goes beyond that, and I think this is either the third or the fourth time I've appeared before you for confirmation. And something that you've been interested in, it's this. And I took it to heart, perhaps you don't remember it, but in my job, my current position on the Court of Appeals, one of the things that I always attempt to do is to make sure that in that isolation, that I don't lose contact with the real world and the real people, the people who work in the building, the people who are around the building, the people who have to be involved with that building, the people who are in the neighborhood, the real people outside, because our world as an appellate judge is a cloistered world, and that has been an important part of my life to not lose contact.
I think that is important, incidentally, and it is, if you are confirmed, I assume that's not a message for me to stop here, Judge. Oh, okay. I think it is important, if you are confirmed, to go out of your way to do that. It becomes very easy, whether you're a senator or a Supreme Court justice, to become isolated. How do I reconcile what I sense are two Clarence Thomases. One is the Clarence Thomas who's testifying here, that Holy Cross student, and the other is the Clarence Thomas that says government cannot be compassionate. And though here you said, I favor public housing, if I can use another illustration, you were in the magazine Reason, you were interviewed, and you say, so would you describe yourself as a libertarian? And you say, part of the answer, I certainly have some very strong libertarian leanings, yes. And then you say, I tend to really be partial to Ayn Rand, the author. She has, when she died, the New York Times had this comment about her. It says, her morality constituted, and I'm quoting now, a reversal of the traditional Judeo-Christian ethic because it viewed rational selfishness as a virtue and altruism as a vice. She was opposed to Medicare. She was opposed to a lot of things that a lot of us would say are part of having a responsibility to those less fortunate in our society. Anyway, I see these two Clarence Thomases, one who's written some extremely conservative and I would even say insensitive things. Maybe you wouldn't agree with that description. And then I hear the Clarence Thomas with a heart. And Senator Heflin says you're in part an enigma, and that is part of the enigma here. How do I put those two Clarence Thomases together, and which is the real Clarence Thomas?
Senator, that's all a part of me. You know, I used to ask myself, how could my grandfather care about us when he was such a hard man sometimes? But you know, in the final analysis, I found that he's the one who cared the most because he told the truth. And he tried to help us to help ourselves. And he was honest and straightforward with us as opposed to pampering us, and prepared us for difficult problems that would confront us. With respect to the statement about government, I think I attempted in the government being compassionate, and I don't have that full quote, but I think the rest of that statement was something to the effect that people are compassionate. Government, in my view, has an obligation to solve those problems and to address those problems. We may disagree as to what the best solution is or as policymakers, but the fact of the matter is that from my standpoint, as a community, as people who live in an organized society, we have an obligation as a people to make sure that other people are not left out. And I think I've said that, and it's important. But as individuals, I think that we have the capacity to be compassionate to others without that obligation, beyond that obligation.
But as individuals, no one will argue with that. But collectively, we also have responsibilities.
Exactly.
Your statement, I don't see how government can be compassionate. Only people can be compassionate, and then only with their own money, not that of others. We have to make decisions here where we're going to say we're going to take some money from taxpayers for public housing, for food stamps, for things that are important. Anyway, this is the dilemma that one of the dilemmas that we face. And it is, well, it is kind of this quote here where you're siding with the privileged in a lot of the things. And that's the reason for my question about South Africa yesterday. One of the reporters said, why did you ask him about South Africa? He's not a nominee for Secretary of State. I want to know what makes Clarence Thomas tick. And in that connection, I don't know if you had, I mentioned the article where you were quoted as protesting or as objecting to the tactics of the protesters at the South African embassy. Did you have a chance to, or does anyone remember any more of the details of that?
Senator, you asked me a question as I remember it, and correct me if my recollection isn't accurate. You asked me whether or not that was coordinated in any way.
Yes.
And my response and recollection remains the same, that to the extent that there was any, to the extent that those comments coincided, I think it was a result of a reporter calling around.
Let me, I also asked about Jay Parker. And yesterday's Newsday, New York newspaper, has this article by Timothy M. Phelps. Clarence Thomas asserted in Senate testimony yesterday that he did not know that his good friend James J. Parker had represented South Africa, although former aides say he did. A former assistant to Thomas, who asked not to be identified, said recently that Thomas brought up the subject of Parker's representation of South Africa in 1986. At that time, Parker and a partner, William Keyes, were being paid more than $360,000 a year to lobby for South Africa as foreign agents, according to Justice Department records. And then I will skip a few paragraphs, but I don't think I'm taking anything out of context here. Thomas was asked yesterday by Senator Paul Simon about a New York Newsday story outlining his relationship with Parker. The 43-year-old federal appeals court judge said he knew that Parker had represented some South African homelands, but not South Africa itself. I was not aware again of the representation of South Africa itself, Thomas said. I was aware of Mr. Keyes' relationship with South Africa. I was not aware of Mr. Parker's. But the former aide of Thomas at the Equal Employment Opportunities Commission said in an interview that Thomas talked about Parker's representation of South Africa for 45 minutes at a staff meeting in 1986. He said that somebody had to represent the South Africans and that if sanctions were passed, it would affect the black people more harshly than supporters of apartheid. Well, I will not comment on that, though I think you would find most blacks in South Africa differing, the former aide said. She said that when staff members entered the room for the meeting, Thomas had with him a newspaper article outlining Parker's relationship with South Africa. She said he asked the staff members what they thought of the article and became very angry when one said it was hypocritical of Parker to take money from South Africans. Do you recall that at all?
No, Senator. As I indicated to you, I understood or I knew about Mr. Keyes' representation. That's the best of my recollection. I did not recollect, nor was I aware until recently, of Mr. Parker's representation. I was aware, as I indicated, about his involvement with the homelands. And I don't know who that aide is or what article she is talking about.
Not recall that
I do
meeting.
not recall that exchange at all. I was aware, however, of his representations and his trips to South Africa and his representation of the homeland, but not the paid representation of South Africa itself. I do remember reading an article at some point indicating the involvement of Mr. Keyes and the significant amount of money that he was paid. I do recollect that.
In the exchange, you mentioned your position on divestiture at Holy Cross, and I commend you for that position. You say, I took a strong position on the Board of Trustees of Holy Cross that we divest of stocks in South Africa. That was important to me then, and of course, that is contrary to a position that they might take, but it was one that I felt strongly about. I have to say I find a little bit of conflict in that and your opposition to sanctions for South Africa. But publication has just come out, says, and I asked you whether this is accurate or not. The Reverend John Brooks, the school's president, says there was no significant board opposition to Brooks's recommendation for divestment, and that he does not recall Thomas or anyone else taking or needing to take a strong stand.
As I indicated yesterday, there was significant discussion, and it is as I recall it at the board meeting.
Okay, so that there was division.
There was no opposition. There was whether or not we would act now or later was the nature of the discussion as I remember it.
The one of the people you quote from in the course of some of the speeches, and in fairness, if somebody went over all of my speeches as carefully as I've gone over yours, I'm sure they could find a lot of things that I wouldn't be too proud of today. But one of the things you say, Thomas said that the Congressional Committee, quote, beat an ignominious retreat before Colonel North's direct attack on it and by extension all of Congress. That was, end of quote. That was a speech before the Cato Institute in 1987. And then in a speech a few months later, you say Congress's aggressive oversight of federal agencies, and then in commenting on it, you in quoting it says, as Ollie North made perfectly clear last summer, it is Congress that is out of control. I am concerned about quoting Oliver North, who I assume you, along with all Americans, knew shredded papers, destroyed evidence. This was done in fairness before he was convicted of a felony. But how does Oliver North end up getting quoted? Someone who has been, who is not, at least in my mind, not a hero, not for what he did as a member of the armed forces, where he apparently was outstanding. But when he shredded paper, when he destroyed evidence, he is not the kind of person I would want to quote. And I would think Clarence Thomas would not want to quote.
Senator, I don't think that I condoned, and in fact, I remember us having discussions about whether or not he had done something improper, and my saying very distinctly that I felt that if he'd done something improper or wrong, that should be addressed. The point that I was making there, and you noted in the context, and I don't have that speech before me, but it was in the context of oversight hearings, and I think during a time when I was having my own difficulty in that oversight process, and that sometimes at those hearings, though they serve the very, very important function of ferreting out facts and responding to those, they can often become highly charged, politicized public events. And I think myself, like many others, felt that in that highly charged political environment that Colonel North took the advantage to himself and used that environment to his advantage as opposed to succumbing to it.
Since you're talking about the process, you have spent 4 days now before this committee, and you have had to go through this grueling process, and it is that. What is your feeling as you reflect upon this process that you're going through? Does it serve the nation well? Does it not serve the nation well?
Senator, even before I was nominated, I was asked that question because when I was nominated to the Court of Appeals, that was not exactly a joyride, and it had its difficulties.
I helped to create those difficulties, as I recall.
Pardon me?
I helped to create those difficulties for you, even though I ended up voting for you for the Court of Appeals.
That's okay, Senator. You know, we each have to, do what we think is best, but I was asked that question then, and my response to people who felt I should have returned to the kind of acerbic comments, I guess, about the process was simply this: that we are, as judges, in the least democratic branch of government. We have lifetime appointments. We make very, very important decisions, and we do not stand for re-election. This process has to work. People can disagree as to the nature of the process. We can say that it's flawed in one way or the other. And even in the speeches where I talk about oversight, I may talk about the flaws, but I also point out the importance of the legislative and oversight process. This process is necessary. And it has, to me, become more clearly necessary since I became a judge. And I have no reason to change that view, and in fact would feel very strongly about it even through this process, even if the process is difficult for me.
Earlier, Senator Heflin asked you about the Fifth Amendment and privacy implications. Let me, I mentioned yesterday, or I guess the day before, we were talking about the Ninth Amendment. And there are in the Constitution some specific privacy things about quartering militia and searching your home. When you combine those specifics with the history of the Ninth Amendment, is there a privacy implication also, in your opinion, in the Ninth Amendment?
Senator, I think I've made 2 points with respect to that. And with respect to the finding of the right of privacy, I indicated that I felt that it was the analysis that I tended to agree with or agreed with was the finding of that interest or that right in the liberty component of the Due Process Clause. The approach that you're talking about, of course, and I think we discussed, was the approach that Justice Douglas took, and similar to that was Justice Goldberg's approach. I think that there's no one really knows the extent to which the Ninth Amendment can be used. There's a considerable amount of scholarly work being done, as I said before, and there may be a point where the court has a case before it in which an asserted privacy right or privacy interest is or could be found in the Ninth Amendment. To date, though, a majority of the Supreme Court has not done that. I would not foreclose it, Senator. But I, with respect to the privacy interests, would continue to say that the liberty component of the Due Process Clause is the repository of that interest.
Let me just lobby you here now, if I may. This is the only chance we get to lobby future Supreme Court justices. I think the Ninth Amendment is a very fundamental protection of basic liberty. And I would hope there's an article written by, I believe, a person named Rappaport at the University of, maybe it's William and Mary, I'm not sure where it is. But I will send you the article that gives some additional background on the Ninth Amendment. I think that is important. We have, I just received today, and I assume my colleagues have received, a letter from 12 subcommittee and committee chairs from the House who work with you in the EEOC, asking well, let me just read the final line, and we put the full letter in the record. We conclude Judge Thomas should not be confirmed as Associate Justice of the United States Supreme Court. his confirmation would be harmful to that court and to the nation. I don't know if you have seen the letter at all. There was a somewhat similar letter when you were up for nomination for the appellate court. Do you have care to comment on that?
As you indicated, Senator, there was a similar letter when I was nominated to the Court of Appeals. And I think, as I may have indicated either privately to you or maybe even in the hearings, I can't remember which, that of course I would want individuals with whom I've had dealings in the past to be supportive of me, certainly to be as supportive of me as the people who worked with me every day. But during my tenure at EEOC, we did have some differences of opinion and some disagreements in a political and policy-making context. I don't think that, I certainly don't agree with them, and don't think...
I did not expect you to agree with their letter.
But I think it's unfortunate, but Senator, we had our disagreements, and I didn't think that they rose to the level to require a letter of that nature. But I can understand that they have to take positions that they feel comfortable with.
Thank you. I see my time is up, and I also see we have a vote over on the floor. Thank you, Mr. Chairman.
Thank you. Judge, Senator Cole, to accommodate your schedule and everyone else's schedule, went over to vote and should be back here by the time we all are up and leaving. The committee will recess until Senator Cole returns, which should be momentarily, and when Senator Cole returns, I would ask the staff to inform him I would like him to begin his questioning before I return, or for him to chair the hearing and start the matter up, okay? We'll recess till Senator Cole arrives.
Scene floor.
I like how they just keep it rolling.
Senator Herbert Cole.
The cameras in the courts.
On like a
Same here, Senator.
And, it's
like a slide that says we'll be right back.
We're awaiting the return of Chairman Biden, but in the interest of expediting the hearing, I will begin my conversation with Judge Thomas. And let me say, Judge, as I said to you a minute ago, I'm not sure if I'll be back for round 3, but I've enjoyed having a chance to talk with you this week. I think you've been just as forthcoming as you possibly could be with the committee, to the best of your ability and to the best of my ability, and I've tried to be honest and fair with you, and it's an experience that I won't forget, and I've enjoyed having a chance to be with you.
Same here, Senator.
I'd like to ask you for a minute about cameras in the courts, Judge Thomas. As you know, many states have cameras in the courts to some extent, and it's been, I think, highly successful in helping to educate the public. Just in passing, I'd like to say that I watch television perhaps 10 hours a week, and I would say 9 or 9.5 hours are C-SPAN, which I think does an outstanding job of educating the American public about public affairs and government, things that are really important in our society if we're to foster a democracy and its growth and enlightenment. It certainly is very important nowadays. But we don't have cameras in the Supreme Court. If you had to make a judgment, yes or no, would you support the experimentation at the very least with the cameras in the Supreme Court? After all, as you know, virtually everybody in this country knows who Judge Wapner is, and no one knows who Chief Justice Rehnquist is. Can we do something about that?
Maybe we should give Chief Judge Rehnquist his own sitcom. Senator, I too watch C-SPAN, and as a citizen have had the same reaction. It's a wonderful opportunity to see our governmental processes at the national level disseminated over the entire country. With respect to the court systems, the only reservation that I would have is that it not be disruptive of the exchange between the court and the individuals who appear before the court. It's a different environment, particularly at the appellate level, than perhaps at the trial court level. But I have no objection beyond a concern that the cameras in the courtroom be unobtrusive, or as unobtrusive as possible. Of course, that's just my own reaction. I have not looked at that in detail.
So you have a positive feeling about it? You think if we can do it without disrupting the activities of the court, you think it would be a good thing for the American public?
I think it'd be good for the American public to see what's going on there. I don't know how long they would be interested in what goes on in appellate argument. It tends to be not so, it doesn't rivet your attention, except maybe perhaps in the cases that have garnered a tremendous amount of publicity. But I see no reason why, beyond that concern, American people should not have access to the courts.
All right. Judge Thomas, no doubt you've been reading the newspapers and listening to members of this committee. It's clear that many here on the committee seem troubled by your failure to answer some of our questions, and others on the committee seem troubled because they think that you've been badgered too much. In terms of your own role and our role, what parts of the process would you keep the same if you could make a recommendation at this time, and what do you think we ought to change to make these hearings as productive and useful as possible, which is, after all, what we're attempting to do on behalf of the American public that we serve?
Well, you know, Senator, I probably would be freer to make that kind of an analysis after the fact. I would certainly love to come back and but Senator, the process of advice and consent is an important process. It's critical, particularly for judges. In the executive branch, we have appointments and serve at the pleasure of the President. As judges, we serve for life. This process may have its flaws, but it is so important that with flaws and all, it's worthwhile. From my own standpoint, just going through the process, of course, I would like to have been able to gone through it in a shorter period of time. But that's not an indication of anything other than the manner and the timing of my appointment. But I think that the process has been overall a very fair process to me.
All right. I'd like to quote from today's New York Times and ask your comment. I quote, "Justice Souter did not feel pressed to remake himself. Rather, his fluent testimony gave the impression that his entire adult life had been a natural preparation for being a justice. On the other hand, in Thomas's case, strenuous efforts have been made to fit what he has described as the proper judicial role. Judge Thomas has at times given the appearance of having wrenched himself from his most authentic personal moorings." Do you have agree, disagree, some feelings about that, some comments you'd like to make as we try to understand you and your background, where you are today, where you've come from?
Senator, let me make 2 points. And one I alluded to this morning. I think that various individuals created their own images of me, and what they see is that the real person doesn't fit those images. I think the more accurate assessments to follow would be the people who've worked with me every day over the past, or for significant portions of my adult career, both in the executive branch and in the judiciary, as well as my other jobs, and not to individuals who have created this persona. I am the same Clarence Thomas. I've been a sitting federal judge, Senator, for about 1.5 years, and the person that you see here is the same sitting federal judge. and someone who attempts to be open-minded, who works at it, being impartial, objective, listen, and to work through very difficult problems. And a final point. When I was in the executive branch, as I indicated to you yesterday, there were battles and there were give and takes. I participated in that, but I'm not in the executive branch anymore. I'm not a part of the tension between the two political branches. I'm a sitting federal judge, and those are entirely different roles. And to the extent that individuals may see legitimate differences, they are the differences in the roles.
Would you agree that if in Justice Souter's case we were seeing a person more natural and comfortable in the judicial setting, it's simply a fact, a reflection of the fact that he has been in that setting for a much, much longer time than you have been in the judicial setting?
I think there's an additional factor in addition to, as well as that, and that is that he did not have 138 published speeches in the executive branch. And he was not in agencies in the executive branch involved in very, very controversial policies in difficult policy areas. And I brought with me a background in some very difficult areas and areas in which people have strong but honest opinions on different sides. And I think that's an important difference. If I had the opportunity to remain as he did in an environment as a judge without those controversial sorts of policy-making positions, and I think much the same would have been said about me, because that's more suited to my personality.
All right. Judge Thomas, you've been extremely critical of the Senate's rejection of Judge Bork. In fact, in a 1987 speech to the ABA Business Law section, you said that the Senate's failure to confirm Judge Bork was, quote, a tragedy. I'm interested in your views on how the Senate should discharge its advice and consent responsibilities. So would you tell us what it was about the Senate's rejection of Judge Bork that was so improper?
I guess, Senator, the point for me there, and again, my approach, as if I were making the decision, I think each member of this body would have to make his own opinion, decide for himself. But my view was that Judge Bork was qualified as to his temperament, as to his competence, and certainly qualified as to his overall abilities. The others may have had disagreements and for other reasons felt that he should have been excluded, and of course you have to discharge your duties in the best way you see fit, but that was my view at the time.
So you're saying your overall assessment of the man is that he was qualified, and simply that fact makes his rejection, in your opinion, a tragedy? Just simply that overall assessment that
the other aspect of it, Don. I thought, again, as a person and someone who knew Judge Bork, that the public, the publicity surrounding him and the characterizations of him were ad hominem in nature, and that the articles that I read and the things that had been said about him simply, even if there were substantial disagreements, attacked the person. And I have, as I have indicated even during my own confirmation processes, I think ad hominem attacks on individuals, even when there are legitimate differences, are just simply wrong. Now, I don't think that this committee, and did not say that this committee engaged in that, but that was certainly a part of the overall process from the outside.
And had you been sitting on this committee, the chances are you would have voted for his confirmation.
Again, that was my view from where I sat, was that as to his competence, as to his temperament, and his, that he was qualified.
Okay. For the past few days, Judge Thomas, you've repeatedly suggested that this committee disregard a number of the articles you wrote and speeches that you made while you were in the executive branch. Using the same logic, should the Senate have ignored Judge Bork's writings because when he did them, he was in another field, another area also, he was an academic?
I think that, Senator, the one point that I made was that if I gave speeches as a federal judge, I thought that particularly those should be closely examined. What I said as a federal judge, my opinions, while I was in the judicial branch of government and into the judiciary, I think that you have to weigh or discount to the best of your abilities or in your judgment speeches that are made outside of the judiciary when one has a different role, for example, a person who's a law professor or a person who's in the executive branch. But I think it would be important to look closely at a speech that I made as a judge.
What I said is that he made many of those speeches when he was an academic, and you made many of the speeches that you have asked us to disregard when you were outside of the judiciary. So using the exact same logic, it would be consistent for you to say that you would support the contention that the things Judge Bork said when he was an academic, if at his request, should be disregarded.
I wouldn't say disregarded, Senator, and I don't think I said disregard everything I've written. I think what I've suggested is that that's a different role.
Qualified, whatever the word is.
Exactly. I think that they're different, and that difference should be taken into account. One is freer to make comments outside of the judiciary and to discuss issues in different ways than one is within the judiciary, just as one is freer to make policies and make decisions in a different way. In the judiciary, it is more confined and I think appropriately more neutral.
Mm-hmm. Judge Thomas, through the hearings, throughout these hearings, when asked about specific speeches or articles, you've said that you've not read or reviewed the articles or speeches recently. Now, the question I'd like to ask is why you haven't or why you didn't in preparation for this hearing. I would have expected that you anticipated being questioned about them. Why is it some of these obvious things that you or your advisors would have forewarned you we're going to be talking about deserved your look? Why wouldn't you have become familiar with them?
I think, Senator, it's there are a lot of speeches, and it's hard to review all of them. What I've attempted to do is review some here and some there, the ones that I felt were going to be raised.
Let's talk about the Lou Lerman article. Now, that was clearly a focus since the day that you've been nominated, and it could have been understood by you or anybody with whom you were having breakfast from time to time that this was going to be asked of you. There was a reason. There's got to be some reason other than I didn't think it was important. I mean, you knew it wasn't. You knew we were going to talk about it, and yet you said at this hearing you haven't read it, not really fully familiar with it. And so, I want to understand that from the point of view of totally believing that. And so explain it to me a little better.
Well, I reread my speech at the Heritage Foundation. What I suggested was I didn't read his article. There is just so much material, Senator. I attempted to read as much of my own material as well as to consider the fact that there was going to be just a vast body of legal material as well as my biographical material, my background, my days at EEOC, my days at the Office for Civil Rights, my opinions on the court.
This was an article that had been referred to dozens of times all summer. And as I recall, you came here, and correct me if I'm wrong, but I think you said, look, I can't really talk about that article because I haven't really read it. I'd have to go back and reread it, so don't hold me for its contents word for word because I'm not really familiar with it. And that was part of your distancing yourself, however sincerely, from natural law and its applicability. But again, in my last opportunity to speak to you, and I want to walk away with the strongest positive feelings I can, I'm puzzled why that, in all the hours that you spent this summer thinking about this week, why that article would not have been an article that your mind or your friends' minds wouldn't have said to you, you have to read it and understand what's in it because it's going to come up.
Well, I guess
it's going to come up.
I guess to this extent, Senator, that my response to questions concerning that article was that I cited it or praised it for a very limited purpose, or stated, made comments about it for a very limited purpose. And I stated what that purpose was, and that purpose didn't suggest, from my standpoint, the need to go back and learn everything about that particular article. The point that I'm trying to make with respect to the volume of other material, there were any number of areas beyond that that have come up also that I've had to attempt to address.
True, but I still want to say, it was clear that this article was going to be discussed in detail because of what you said about it with relationship to natural law and its applicability. It was clear. There may have been other things too, which you're alluding to, but it was clear that this one was going to be talked about. So I think it's logical for me to ask the question and expect some answer on that I can feel comfortable about, why you wouldn't have come here fully familiar with the article and what it said, and the fact that you had, as I said, regarded it with great admirability.
Well, I guess I would have to respond to that in a similar manner to the way I just simply did, and that is that I did not refer to it for the portions of the article that raise the questions.
Okay. Last subject, and that's antitrust law. Judge Thomas, last year we celebrated the centennial of the Sherman Act. For over 100 years, this landmark measure has protected the principles that we hold most important, competition, fairness, and equality. The antitrust laws are important to us because they ensure that competition among business of any size will be fair and that consumers will pay the lowest possible prices for all sorts of goods that they buy. These laws, as you know, are nonpartisan. They've been vigorously enforced by both Republican and Democratic administrations. I know you've worked on antitrust issues as both an advocate and a judge. In fact, in a 1983 speech, you suggested that we create treble damages for violations of the civil rights laws so that they would have the same deterrent effect that the antitrust laws have. My question is, do you agree that the antitrust laws have been very important in shaping our economy?
Senator, I think that all of our efforts, including the antitrust laws, to keep a free and open economy, one in which there is competitiveness, where the smaller businesses can have an opportunity to compete, and where the consumers can benefit from that. Those efforts, including the antitrust laws, have been beneficial to our country from my standpoint.
Judge, do you believe that an important purpose of the Sherman Act is to protect against consolidation of economic power, to make sure that consumers are not charged high prices by large companies that have swallowed up their competition? An important purpose of the Sherman Act is to protect against consolidation of economic power.
Yes, Senator.
All right. So that you believe the principal beneficiaries of vigorous enforcement of the antitrust laws are the consumers primarily. That's how you...
I think the consumers and the country benefits from strong competition. We certainly, as consumers, benefit when there are new products, when there's development of products, when the quality of the products are improved as a result of competition, and of course when there is no temptation toward supra-competitive pricing. In fact, pricing is at the lower levels.
All right. Well, then how do you square this philosophy, with which I agree, with a decision like the Illinois brick decision, which bars the actual victim of any price fixing from recovering damages, which would, for example, prevent mothers claiming that they were victimized by a conspiracy among infant formula companies for filing suit and collecting damages?
I can't say exactly, Senator, how I would square it with that opinion. Certainly from my answers and certainly from my own position, I would be concerned if any consumers are having a more difficult time raising challenges in areas where they've been harmed by practices of unfair practices or unlawful practices of businesses.
So a decision like Illinois Brick is a decision that if it came before you again in a similar fashion, you might review that with great interest.
I would certainly be concerned when consumers don't have access to our judicial system to have their injuries as a result of unfair practices or illegal practices or unlawful practices remedied.
All right, Judge Thomas. I'm concerned that some judges would disregard the legislative intent of the antitrust laws and substitute their own ideological agenda, an agenda that may mean helping large corporations and ignoring consumers. So I'd like to read you a statement by Judge Posner of my own Seventh Court. If the legislature enacts, and I quote, into statutory law a common law concept as Congress did in the Sherman Act, that is a clue that the courts are to interpret the statute with the freedom with which they interpret a common law principle, in which event the values of the framers may not be controlling at all. Do you believe that this is a legitimate approach to interpreting statutes in general? And should the courts interpret the Sherman and Clayton Acts without exploring the legislative intent of its authors?
Senator, as I've indicated, and I think it's very important for a judge to always be in search of and adjudicating a case or interpreting a statute on the intent of the legislature, and certainly not to ignore that intent and not to substitute his or her point of view or predilection for that intent.
All right, my last question is on resale price maintenance, Judge Thomas. Talking about price fixing for a while, for just a minute, because it's particularly of concern to me with my background. Since the Dr. Miles case in 1911, we've had in this country a rule that prohibits the manufacturer from dictating the retail price of his product. But some people have begun to argue that we should treat vertical price fixing differently from horizontal price fixing. And Robert Bork suggested in the Antitrust Paradox that it should be completely lawful for a manufacturer to fix retail prices. Would you comment on that, please?
Senator, I have no basis and have had no basis to take a position different from the one that finds that there are problems or concerns or perhaps illegality in vertical price fixing, or that vertical price fixing be exempt from the antitrust laws. In short, let me restate that. I have had no reason to argue or basis to argue that vertical price maintenance should be exempted from the antitrust laws.
Thank you very much, Judge Thomas.
Thank you, Senator.
Judge, it's my responsibility to ask questions now, but one of our colleagues, again, based on our assertion, our statement at the outset that we would end early on Friday, and we're going to try, we may have to go later than early in order to finish, has a plane to catch. And so with the permission of my colleagues, I will go out of order and yield to him now and then go back to me. And I yield at this time to my colleague, Senator Grassley. It will not affect who gets to ask questions next, except it will indirectly affect Senator Thurman. You're next in line after me. No, I haven't.
Well, go ahead.
No.
Thank you, Mr.
I was just trying to.
Chairman, you go next.
Well, yeah.
Thank you, Mr. Chairman.
It's seldom that it's recognized that I am the chairman by the chairman, but I'm delighted that I'm the chairman. Senator Grassley.
Thank you, Mr. Chairman. Judge Thomas, if I could go back to an area that we discussed yesterday, the privacy area, and set a little background by reminding you in response to the chairman's question, you agreed that, and quote, single people have the same right of privacy as married people on the issue of procreation, end of quote. And you agreed with the chairman that, quote,
the privacy right of an individual is fundamental, unquote. Yesterday I tried to find out parameters on the constitutional right to privacy. And let me make very clear, I don't expect you to prejudge any case. But if I could, I'd like to get an idea of the framework of the test to be applied in analyzing privacy rights. You've endorsed the rationale and the holding of Eisenstadt. Yesterday, Senator Simpson and I raised the Bowers decision. Now, the dissenters in Bowers found that Eisenstadt compelled the opposite results from the outcome that the majority reached. So the four people on the dissent were doing it on the basis of Eisenstadt to recognize a broad and sweeping constitutionally protected privacy rights. So I hope that this puts it in a context where you understand my concerns and why I'm bringing this up again. I wonder if your endorsement of Eisenstadt could lead you to the same conclusions that the Bowers dissenters reached.
Senator, I don't think that the majority in Bowers in any way felt compelled to undercut Eisenstadt in order to reach the conclusion in which they did, or that they did. Again, I have not gone back and reread the majority opinion in that case, but I believe what the majority did is simply say that in looking at our history and tradition that the privacy, fundamental right of privacy did not include homosexual sodomy. I believe that was Justice White, but the point is that it left intact the holding in Eisenstadt that the right of privacy attached to the individual.
Okay. Well, that helps me a little better and it makes me feel better from the answer that you gave yesterday. You agree that the right of privacy is not absolute. Indeed, its protection is derived from the Liberty Clause of the 14th Amendment as part of the Constitution. And so basically, I guess then in conclusion, and this is the only question I have of you in this round, I would like to read from you, for you, a portion of the majority opinion in the Bowers decision, and it's a few sentences long, so I hope I read it carefully for you. Quote, "The court is most vulnerable and come nearest to illegitimacy when it deals with judge-made constitutional law having little or no cognizable roots in the language or design of the Constitution. That is to say, or that is so, pardon me, let me quote again. That this is so was painfully demonstrated by the face-off between executive and the court in the 1930s, which resulted in the repudiation of much of the substantive gloss that the court had placed on the due process clauses of the 5th and 14th Amendment. There should be, therefore, great resistance to expand the substantive reach of those clauses, particularly if it requires redefining the category of rights deemed to be fundamental. Otherwise, and this is the last sentence, otherwise the judiciary necessarily takes to itself further authority to govern the country without express constitutional authority." So I think you probably have stated already, but as this is sort of a summary, can you agree that this expression of judicial restraint is an important consideration in determining the parameters of the right of privacy?
Senator, I think that in areas in which a court or a judge is adjudicating or interpreting the more open-ended provision of the Constitution, that judges should restrain themselves and from imposing their personal views in the Constitution. that their adjudication must be rooted in something other than their personal opinion. And as I've indicated and the court has attempted to do, and attempted to root the interpretation or analysis in those areas in history and tradition of this country, the liberty component of the Due Process Clause. And I think that that is an appropriate restraint on judges.
Does what you just said, then, is that your way of telling me that that
Yes.
you agree with that?
Yes.
Those statements? Thank you, Mr. Chairman, and also thanks to my colleagues for the courtesy of going out of order.
Now, as I understand it, there is this may be an appropriate time to take a break. Is that so? We will break until 3:30.
It's a good time to step in and chat and say, you know, I could come off mute and talk, but like, look at the people who want me to come off mute and argue what they want me to argue with them about. A, I'm trying to watch the hearing. B, no one cares about your battle with the N-word as it is, and you really want to be able to say it, but it just, gosh, I mean, people just won't let you say it. It's like there's more important things that are being censored, let's say, that I care about. I don't care about your individual right to say the N-word at all. And I don't want to even give it that much more oxygen, as Matt has pointed out. But, you know, this is as good a time as any to recap what we've heard about today. And, you know, it's interesting what they ask, you know, who is Clarence Thomas? Why did you go to law school? Are you a different person today than you were? And, of course, he is a different person with different with a different perspective on life. He wanted to change things like every 20-year-old does. You know, he was marching. He was an activist at some point, it seemed like, during the Civil Rights era. Those are things that came up today that they didn't come up as much in day 1, 2, or 3. Day 1, 2, and 3 were predominantly about natural law versus the Constitution. It was interesting. And, you know, he said, you know, obviously it's something you got to think about when you think about what the framers were thinking about. But as far as I'm a judge and how am I going to rule, it's going to be by the Constitution. Other things that came up today, affirmative action came up, and he said, you know, am I a beneficiary of this system? Yes, but I also think, you know, there's been a time and a place for it, and maybe that time and place is over. I believe, you know, my philosophy is developed, and I believe in meritocracy is, you know, how I would phrase that. And now I don't want to keep you too long listening to me just recap it for you.
Say after consultation with...
Let's get that gavel. I want the... No. Gaveling in.
Hearing will come to order. Let me say, after consultation with Senator Thurman and with Judge Thomas, it looks like our best efforts to get finished today, finished in the sense that Judge Thomas's testimony is finished, is not going to work. We would be here well into the night for that to happen. But it also looks like, after consultation with Judge Thomas and with Senator Thurman, that we can get still a good hour and a half more, maybe even more than that, in today, and that we will start at 9:30 on Monday morning, and I believe that we can finish by lunch on Monday. That will be the chair's express intention, and it looks like that is very reasonable, that could be done. So, Judge, instead of being finished today at 5, you will, in all probability, be finished at lunchtime on Monday. So, why don't, with that, we just get underway and see how much more we can get finished tonight if everyone is agreeable. Now, unless I have miscounted, I believe it's my turn to ask some questions, Judge, and I'd like to go back and ask one very straightforward question, because it's been mentioned 87 different ways by 6 or 8 different people. And I don't think you in any way have confused it. I think maybe we have confused it. We, the members of this committee, Republican and Democrat, and as I've read some of the press accounts, the press even seems mildly confused on it. Again, not you. I think you're perfectly clear on it, but let me make sure my recollection is right. I want to ask you a very precise question, similar to what I indicated I would ask you. And if it requires more than a yes or no answer, obviously elaborate. But if you can answer it yes or no, it sure will save a lot of time and be on point. Judge, very simply, if you can, yes or no, do you believe that the Liberty Clause of the 14th Amendment of the Constitution provides a fundamental right to privacy for individuals in the area of procreation, including contraception?
Senator, I think I answered earlier yes, based upon as the precedent of Eisenstadt v. Baird.
Well, you know, what folks are going to say is that Eisenstadt v. Baird was an equal protection case, all right? That's not the question I'm asking you. Let me make sure. I'll say it one more time. Do you believe the Liberty Clause of the 14th Amendment of the Constitution provides a fundamental right to privacy for individuals in the area of procreation, including contraception?
And I think I've answered that, Senator, on that.
Yes or no?
Yes, and
I like it. Not I like it. I think we can end confusion. If it's yes, the answer is yes.
Well,
if you want to go on, go on. But
well,
I mean, I think that's what you mean, but
I've expressed on what I base that, and I'd leave it at that. But
okay, let me let's switch to what I thought was a very, very interesting and informative exchange you had with Senator Brown earlier. Now, we don't have the actual record because it's not able to be transcribed as we move, although they do a phenomenal job of transcribing it quickly, and we don't have it yet. But here's what I understood that exchange to say. In your exchange with Senator Brown, Senator Brown, in my view, accurately stated the law. He said, and Supreme Court decisions. He accurately stated the law and the state of decisions in the court as to where the law now stands with regard to the standard of review that judges use in determining whether an action taken by the government against an individual is constitutional, against their individual rights of privacy or against their individual right relating to their property. And he pointed out that when the court looks at whether an action by a state to limit an individual's fundamental right to privacy, like in Griswold or Moore, the state has an overwhelming burden. He pointed out that the court says the state, in those kinds of cases, has to apply a standard of strict scrutiny. They have to have an overwhelming reason to justify their action impacting upon that person's right. But, he went on to say, if a state impacts on a person's use of their property, they now apply a rational basis test, he said. Now, by that he went on to explain that the court looks at the state and determines whether or not it had a rational reason for impacting on that person's property right, not an overwhelming reason, a lower standard. Senator Brown said that he thought this was wrong. He said that property rights should not be separated out in that way. And he went on to point out, if my notes are correct, that property is the basis of all our moral rights. And he further pointed out that he said, I believe this is a quote, "The courts ignore this reality now." Senator Brown then cited Moore versus East Cleveland as an example of the failure of the Supreme Court to recognize what he calls the reality of their mistake. He said that Moore was a violation, the way the Supreme Court ruled, Moore was a violation of the right of someone to use their property. He then quoted as authority for that Professor Tribe. He probably knows it, but he didn't bother, he didn't have an opportunity to say it. He quoted Tribe's comments on Lynch versus household finance. That's what, when Tribe, the quote he read was about Lynch versus household finance, although he didn't state that. Not about Moore. Now, he then looked at you and he said, do you agree? Do you agree that these two different standards, the court has a strict scrutiny standard for matters with regard to privacy and matters with regard to other things other than property, race, suspect categories, classifications. They have this standard, and with property they have this standard. And he said, that's wrong. Do you agree? And the answer you gave, as I understood it, was exactly the opposite of the position he staked out, if I understood it correctly. You said you have no quarrel with what the court does, how the court deals now with regard to regulations of property. You said that this is where the court should defer to the legislative branch. As you and I know, there's a venerable theory in constitutional law that says the reason why there should be a strict scrutiny standard on matters like privacy and suspect categories is because that's where democratic institutions have erred the most. That's when the legislative bodies have made the most mistakes, like saying people can be slaves. So, historically, we've applied a stricter standard. But, as you pointed out, in areas where it related to property, legislature didn't err that much. That's the basis of the thesis underlying the argument. The point, I should say. They don't err that much, so the courts have been more ready to rely on what the legislature says. Different standard. And you went on to say, I don't quarrel with this approach. That was the quote I do remember writing precisely. Now, Judge, either you completely, fundamentally disagree with everything that Senator Brown said and he thought you agreed with him, or the following. You said you had no quarrel with the equal protection analysis in this area, which is, of course, the area where terms like rational basis and strict scrutiny are most often used. But of course, Judge, technically, we're not dealing with the equal protection analysis when we're talking about the taking of property, as you well know. We're dealing with the Fifth Amendment and the due process analysis. Now, there's always two questions in analyzing whether a regulation is valid, whether the regulation by the government to regulate somebody's property, take their property, is valid. I can see the press and others are bored by this, but this is the single most important question you can be asked in this entire hearing. One of the tests they apply is whether the object that is being served by the law, taking the property, is an object that falls within the scope of police power. And the other, as you well know, is whether the means chosen to legislate accomplishes an objective that's reasonably related to the reason they say they're doing this thing. Now, Judge, The court's current approach is to give the legislature a broad latitude in both these areas. The area of determining whether or not the means is an appropriate means, and whether or not the objective being served is an objective that falls within the police power. That's the state of the law now. And they essentially apply a rational basis test or a much lower standard. So my question is this: do you agree with the state of the law as it is now with regard to property, as I understood you to say it? Or do you agree with Senator Brown, who said it's wrong the way we're doing it now? Property and the test applied to the taking of property should be elevated to the same level as other constitutional rights, i.e., the case he cited, the right to privacy and more. What is your position?
Senator, I think that, and I indicated to Senator Brown, as well as I believe to a question from Senator DeConcini on equal protection analysis, that the current manner of equal protection analysis I have no quarrel with.
Do you have a quarrel? I'm sorry, go ahead.
With respect to the area, the current law in the area of taking, I have no basis to quarrel with that either.
That's what Senator Brown was talking about.
Well, I thought that he recognized that we disagreed.
That's what, okay, good. That's what I want to make sure, because
I thought that was recognized.
Because I thought Senator Brown, please correct me if I'm wrong, I thought Senator Brown said, well, I understand, we agree, and you know, property should have a higher scrutiny and should be treated with more respect in the law, and et cetera. I thought he thought you agreed.
I was doing my best to get him to agree.
But you are aware that on the record, under oath, he does not agree with that.
And was very disappointed that he disagreed with Professor Tribe.
I got it. Well, if you have an opportunity to read the case that Tribe was talking about, you'll know that it is not related to the issue that we're talking about. Anyway, now, and that I don't mean to defend Professor Tribe. I don't care one way or another whether Professor Tribe is right or wrong. It's just that it doesn't relate directly to this issue. Now, Judge, the reason I bothered to take you through all that is I think you know well, and that is that it is a big deal, at least to me, and a big deal to, in fact, to this country, that if the theory and thesis promoted by Senator Brown, espoused in great detail with significant annotation and with great articulation, and it's a first-rate book by Professor Epstein, if you agree with this view, it means that, as Professor Epstein, the Brown-Epstein view, it means very simply that, to use his phrase, that, let me get it straight here, if what follows, I shall advocate a level of judicial intervention far greater than we now have, and indeed far greater than we have ever had. That's what's being advocated by a very brilliant, informed, respected school of thought. Now, I won't go into all the nuances of it. You understand them well. I might add that a couple newspaper articles have written about this thesis. It has nothing to do with natural law. Let me quote from the book so they're informed. Quote from Mr. Epstein: thus, the political tradition in which I operate and to which the takings clause itself is bound rests upon a theory of natural rights. I read from a very informed newspaper that natural rights had nothing to do with this theory. It's the thing upon which his theory is based. So, I am happy to hear your answer. If you'd like to elaborate or speak on anything at all about this subject matter, I'd be delighted to hear it. If you don't, it's okay too. It's up to you. I don't want to cut you off. All right. Now, let me move to another area, if I may, and that is to the area we've touched on very briefly, religion, if I may. Not your religion or mine, how the court deals with religion. Judge, this is, there's one area where the level of protection accorded fundamental rights is changing, and I don't think most of us even know it. You know it, I mean, but and that's the right of free speech and the free exercise of religion. These rights, which perhaps more than any other are central to what most of us believe to be what it means to be an American. In my view, these rights deserve the highest level of protection by the court, and I'd like to start first with the free exercise clause of the First Amendment, which provides, as you well know, quote, Congress shall make no law prohibiting the free exercise of religion, end of quote. Now, until last year, the Supreme Court applied the standard known as strict scrutiny when reviewing legislation that restricted religious practice. Under the strict scrutiny standard we've discussed a number of times here, but it bears repeating, the state first needed a compelling reason for restricting the religious practice, and second, the state had to show that no other alternatives were available for it, the state, to achieve its goal. It's been a test now for about 40 years, 35 years. Two-pronged test. Under this doctrine, the Supreme Court held, for example, that the compulsory education law could not be used, for example, to require Amish children to attend school when their parents believed they had a religious duty to be educated at their home, the Yoder case, Wisconsin versus Yoder. The court reasoned that even though the state wasn't acting out of any hostility, and even though the state had a compelling reason for making children attend school in general, in Yoder they held the state law could not constitutionally be applied to the Amish because there was, quote, no compelling reason for abridging their religious freedom to educate their children. Then last year, the Supreme Court decided the case of the Employment Division of Oregon versus Smith. In the Smith case, the court held that the free exercise clause permits the state to prohibit sacramental use of peyote. I think that's how it's pronounced. Is that correct? Never having used it, I'm not sure of the pronunciation. Peyote. It's a drug used in an Indian ceremony. And it's been used historically by them. And thus a state could deny unemployment benefits to those who were discharged from employment for such use. Now, I don't want to discuss the specific facts of the case, nor its specific outcome. Instead, I want to ask you about your understanding of the reasoning the court used in this case. Justice Scalia, writing for a 5-4 majority, concluded that as long as the government is not specifically trying to restrict religion, or as long as it's not trying to discriminate against religion, it can apply a general law against a religious activity, and it doesn't matter what effect the law has on that religion. In a sense, striking down what the last several decades has been the second test needed to be passed in order for the state to be able to take such action. In other words, even if the law passed by the government has a devastating impact upon a religious practice, the law is still constitutional, according to the majority, Scalia writing for them, is still constitutional so long as the government acted with a legitimate purpose when it passed the law. Now, Justice O'Connor, on the other hand, said, she would have upheld the ban on peyote without changing the legal test that has historically been applied, without abandoning the strict scrutiny test. Now, Judge, which approach do you agree with? Not whether or not it should be outlawed or not outlawed. It's not the issue as far as I'm concerned. Do you agree with Scalia's approach, or do you agree with O'Connor's approach?
Senator, I think as I indicated in prior testimony here, that when the Sherbet test was abandoned or moved away from in the Smith case, I think that any of us who were concerned about this area, because as we indicate, I think we all value our religious freedoms, and I think that there was a proper and appropriate reason for concern. And I did note then that Justice O'Connor, in applying the traditional test, reached the same result. I cannot express a preference. I've not thought through those particular approaches, but I myself would be concerned that we did move away from an approach that has been used for the past I guess, several decades.
You've obviously know the area well. You've obviously know the facts of the cases. You obviously have an intense and deep commitment to religion and your faith in God. You mean to tell me you haven't thought, when this came out, whether or not which approach you thought was appropriate?
Let me restate my answer. Okay. My concern would be that without being absolutist in my answer, my concern would be that the Scalia approach would lessen could lessen religious protections.
Well, Judge, as a matter of fact, it does. I mean, it's not whether it could or should. It may not be. I mean, it does. It delimits the protection. For example, in the case, I guess it was in New Mexico? In New Mexico, where they passed a law saying minors can't drink wine under any circumstances. And as you know, in our church, in many churches, there's a sacramental taking of wine at communion, and you are able to, in most churches, that occurs. In most Christian religions, and I can't speak for others, occurs when kids are 7 years old or 8 years old. And it impacts significantly. And so, it was struck down, that restriction, in New Mexico. It never got up to the Supreme Court, to the best of my knowledge. But clearly, under the test applied by Scalia, such a law could be passed and it would be held constitutional. Has a big impact. It's a big deal. Not a minor thing.
And I guess my point is our concerns are the same, that any test which lessens the protection, I think, is a matter of concern. The point that I'm making, though, in not being absolutist, is that I think it's best for me as a sitting federal judge to take more time and to think that through. But my concern about the approach taken by Justice Scalia is that it may have the potential and could have the potential of lessening protection. And I think the approach that we should take certainly is one that maximizes those protections.
Judge, when your confirmation is over and if you're on the bench and you're on the bench and the next nominee comes up, they now talk about the Souter standard, how Souter didn't answer questions that some suggest he should or shouldn't have. I'm not making a judgment on that. We're going to have a new standard, the Thomas standard, which is you're answering even less than Souter. Okay, let me decide what I want to do about that later.
First of all, Mr. Chairman, I don't think that's true.
I think he's answered forthrightly and very straightforwardly all the way through this thing.
Well,
now,
let me
he
be
may not
precise.
give the answers that you and I want.
No,
but,
no, I'm not looking for an answer that I want. Let me make it clear, Senator. I'm just
think it's
making
been
a statement of fact. I asked the precise same question to Judge Souter. Judge Souter, a sitting, not federal judge, sitting state court judge, said, I agree with O'Connor. No ifs, ands, buts about it. Just click, bang. I agree with O'Connor. That's the only point I'm making.
Well, but he's answered things that Judge Souter hadn't answered. So, I mean, you know, I'm saying...
I can't think of any, but maybe he has. Maybe he has. All right. Let me... Sure, of course.
Bring up.
Sure.
Thank you. I thought it perhaps was worthwhile, while the transcript is not out, as you noted, to note a couple things that had been discussed. First, my concern about having property rights treated as second-class rights. I did not mean to indicate that property rights are the basis for moral rights. I do believe they're integral, that they're interdependent, but I don't believe that's the basis for it. Secondly, the tribe citation was meant to indicate their interdependence, not necessarily as a support for more. And thirdly, at least my view of it is that tribe showed the interrelationship between personal and property rights, not necessarily having a different implication than that. So I cited it for its interdependence of those rights, not for another purpose. You're trying to allow me to interject
I didn't
within your
misunderstand,
time.
though. You do think Moore was wrongly decided. You did say that.
No, I cited Moore as an example of a case where it is very difficult to separate personal rights and property rights, where the problems that were exemplified by Moore clearly affect both.
Right. Well, I thank my colleague, and I think that's a perfect case, because where two rights come in conflict, the right of the government to tell someone that they cannot live in an area unless they live in that area with what is defined as a traditional family, and that a woman moves in, lives there, grandparents live there, and they have two grandchildren who are cousins, not brothers and sisters. And the state, in the form of the county or city, East Cleveland, says, you must leave. You are violating our laws, our zoning laws, which affect property. And the Supreme Court says, wrong. There's a basic fundamental right to privacy for grandmom to have her grandchildren, even though they're cousins and not brothers, live together. And the reason I raise this is a perfect example of this. That's why I raised the White House Working Group report. I don't want to go into whether or not you signed it or didn't. I'm not talking about you now. There are a number of very intelligent, very well-intended, and maybe even right, but people have a very different view than I do. And I believe you are one in this score, Senator, who argue that, hey, not you, I'm not talking about you, Judge, I'm talking about my colleague. But there's a whole group of people in this town, in this country, who say, wrong. We ought to let states, counties, cities make those judgments. And if they do, they should be upheld by the Supreme Court. I think, from my perspective, is how I read the Constitution, I think that is absolutely, categorically wrong to say that the state should be able to tell a grandmother she can't have two grandsons living in her house. Fine kids, no problems. Can't have her living in the house because they're cousins and not brothers. I think that's bizarre. But there are a lot of people who don't think it's bizarre, and that's why I asked you questions about that. Because if you thought that way, Judge, which you said you didn't, but if you did, I would do everything in my power to keep you off the court. But you don't. So you said, and I believe you, So my time is up, but that's what the debate is about. That's why I'm asking the questions. I can think of no way to frame it better than was just framed in terms of your discussion with me, Senator. Now I yield now to my colleague from, my time's up, my colleague from South Carolina.
Thank you, Mr. Chairman. Mr. Chairman, I have no questions on my own, but I'll reserve my time in case something comes up I have not anticipated. I do have one question to clear up something that was asked this morning by Senator Leahy. Judge Thomas, this morning when you answered Senator Leahy's question about important Supreme Court cases, did you understand him to be referring to important cases decided when you were in law school?
My understanding that he was asking me for cases decided during the period that I was in law school from 71 to 74, and I think I answered him in response to that Griggs and Roe v. Wade.
I just want to clarify that if there's any question about it. Now, Mr. Chairman, let's see, who was it? I believe the distinguished senator from Illinois brought out that 12 members of the House had opposed you. Is that correct? Well, Mr. Chairman, I wish to offer for the record a letter signed by 128 members of the House endorsing Judge Thomas, several of whom are Democrats. I ask that be made a part of the record.
Without objection, it will be made a part of the record. You finished? Okay.
I reserve the rest of my time.
Senator Kennedy.
And Judge Thomas, let me just say this.
Excuse me.
Since I think I'm through, unless something comes up I don't anticipate, I want to compliment you on the way you've conducted yourself here. I think you've shown you're fair, you're open-minded, you answered all the questions you could without violating your oath that you have to take as a judge on cases that might be coming up in the future. We're very pleased with the way the hearings went. I want to compliment the Chairman, Senator Biden, and other members on this hearing and the way it's been conducted throughout. In my opinion, you deserve to be confirmed on the Supreme Court, and I anticipate you will be.
Thank you, Senator.
Thank you very much, Senator. Senator Kennedy.
Thank you, Mr. Chairman. If it's agreeable with the other members of the committee, even though I'm entitled to the half hour, Senator DeConcini will be at the Gates hearing on Monday. What I'd like to do is just, there were 3 areas I'd like to get into. I'd like to divide the half hour with Senator DeConcini, take 15 minutes. He'd take, or try and even take less time and give the remaining time to DeConcini and then go back over to the other side. But I'd like to be able to, at a reasonable hour on Monday, to be able just to finish up those additional areas.
Without
if that's
objection,
agreeable.
and you will be in. There's no objection.
Judge, the right to vote is at the very core of our democracy, and the Voting Rights Act has been extremely important in assuring that all Americans can exercise that fundamental right. In a speech at the Tocqueville Forum in April '88, you criticized Supreme Court decisions applying the Voting Rights Act, and you said, and I quote, "Unfortunately, many of the court's decisions in the area of voting rights have presupposed that blacks, white, Hispanics, and other ethnic groups will inevitably vote in blocks. Instead of looking at the right to vote as an individual right, the court has regarded the right as protected when the individual's racial or ethnic group has sufficient clout." Do you remember what Supreme Court decisions on the Voting Rights Act were that you were referring to?
I can't remember precisely, Senator, but I was perhaps referring to the effects test. Again, that's been quite some time. I do know that I also was critical of the administration for not supporting the Voting Rights Act. And I do treasure, of course, coming from a background or an area where that right was considered enormously important and difficult to secure.
Well, I think in the prior to the meeting, I think we made available to the Justice Department that we would be talking about to the voting rights cases. I gave, I believe, some notice that I'd be getting into these, because it's. I read through your speeches where you talked about the administration's position on the extension of the Voting Rights Act, but also in the speeches has the criticism of the Voting Rights Act, and I think in the speeches you were, as I mentioned here, you were talking about the ethnic group have sufficient clout, and you were critical generally, as I understand, of many of the court's decisions. There were only really 3 important decisions by the courts. You've mentioned one. Yeah. The other 2 were the White decision and the Thornburg decisions.
Senator, my only concern would have been that in that context, whether or not we were assuming that, for example, if you had an all-black district or an all-white district, whether that would necessarily always be good for black Americans. And I think some of the concerns would be that even now, as I've followed in the newspapers or in other journals, that perhaps some of the black individuals feel that the white district that's left becomes more conservative and offsets the newly created minority district. That would have been the only concern. I certainly have absolutely nothing but the greatest support for legislation that secure the right to vote.
Well, of course, the point that you make here is explicitly prohibited by the Voting Rights Act, which says that the Voting Rights explicitly says no group is entitled to legislative seats in numbers equal to their proportion in the population. The Act simply bans states from taking actions which result in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color. And in these 2 cases, they basically struck down the at-large districts, both in North Carolina and also in Texas, specifically in Dallas, Texas, and San Antonio. And I was wondering if, otherwise what we can do is come back on Monday and give you a chance to review these if you'd like. That's fine. I thought I had mentioned to the Justice Department that we get into it.
Oh, you did, Senator, and the underlying concern that you have is the same as the one that I have, that minorities have the ability to vote and to have an effective participation in our political processes. My concerns were not intended to suggest that I was in any way opposed to voting rights or concerned that we have them. I think that they're critical, and I certainly have been most supportive and felt that we should have been more aggressive in stating that position during the Reagan years.
Well, maybe it would be I understand reading your speeches that you were in support of the Voting Rights Act. It also in your speeches you talked about the criticisms of the Supreme Court on the voting rights. And what I was interested in is finding out, what the nature of the criticisms really were.
It was just generally.
It said many Supreme Court decisions in voting rights are unfortunate, and I'm just trying to find out what aspect of the Voting Rights Act that was decided by the Supreme Court and the major Supreme Court decisions affecting the Voting Rights Act dealt with at-large districts in the areas of which I've just outlined. And I was just trying to understand what in particular the Supreme Court decided on voting rights that you've found objectionable. That was basically my question.
And I think my only concern, Senator, was with the effects test, but it was not. I did not go in detail into the voting rights cases, and that certainly was not my area. But what I'm trying to, I guess, communicate to you is that my view is that voting rights should be aggressively protected, and I felt that we should have done that during the Reagan years.
Yeah. Well, we all agree. What was your trouble with the flex test, the holding?
Well, I guess the only point that I was making, Senator, was the whether or not it was on, and again, this is general, the whether or not we could really judge from the number of individuals who held office, for example, how effective a person's voting rights were being implemented, or how effective the statute was being implemented, or how effective the minorities were in participating in the political process. I think it is one measure, and I felt that it was one measure. But I underscore that by saying this, Senator. I did not study that area in detail. That was simply a concern. And I think that other individuals now are concerned because of the creation of what is perceived as more conservative districts, of political districts.
Well, do I understand you correctly that in two of the major decisions by the Supreme Court that struck down the at-large districts, both San Antonio, Dallas, also in North Carolina, at-large districts which historically had been in effect for years by individuals that wanted to deny effective rights to a vote by minorities, blacks and Hispanics. That in one case, in the White case, was decided unanimously by the Supreme Court, that there had been a significant diminution of the effectiveness of the right to vote in Dallas and as well as in San Antonio. That I understand that their requirements that they go to single-member districts is not offensive to you.
Senator, I would again would go back and look at those cases consistent with what you're saying, but I underscore that by saying that that was my general concern. It was not an objection to the aggressive enforcement of the Voting Rights Act.
Perhaps over the weekend, if you can sort of refresh recollection about what were the particular aspects of the voting right cases, because this was something that many of us were very much involved in here at the time of the extension. How much time does I have just 5 minutes left of the 15. In your article in 1989, the higher law background of the Privileges and Immunities Clause, the 14th Amendment, one of the arguments you made for using the natural law to interpret the Constitution was that it is, and I quote, the only alternative to the willfulness of both run-amok majorities and run-amok judges. I think those words have been used at other times of the hearing. Are you willing to name any judge whom you consider to be a run-amok judge?
Senator, I thought about it when I looked at that language again, and I couldn't name a particular judge.
Well, it was Oliver Wendell Holmes a run-amok judge?
He was a great judge, and there, of course, we all, when we have opportunities to study them, we might disagree here and there, but I had occasion to read a recent biography of him, and obviously he's a giant in our judicial system.
Because you, in your speech on how to talk about civil rights, you called Justice Holmes a nihilist, who, and I quote, sought to destroy the notion that justice, natural rights, and natural law were objective. And you went on to say about Holmes, and I quote, no man who's ever sat on the Supreme Court was less inclined and so poorly equipped to be a statesman or to teach.
I think that was a quote from someone else, Senator. I may be wrong on that, but I think it was a quote from someone else.
I don't. I'll provide that for you over the weekend. Maybe you get a look at it. My time is, whatever time is left, I'll yield to the
Senator Kennedy, thank you very much. I'm sorry to impose on you and the committee, but I do intend to be at the Gates hearing. I only have a couple of follow-up questions. I may not even take 15 minutes, Judge Thomas. We were, yesterday when I was asking some questions on judicial activism, I made reference to Missouri versus Jenkins, which is a current case, from 1990. And as you will recall, that is a case where the court imposed an increase in taxes, if you will recall. My only question that I didn't quite get from you because of my own inadequacies perhaps is, do you believe that taxation
within the federal power of the federal bench, or is taxation power exclusively that of the legislative branch of government?
Senator, I think that's explicit in the Constitution that that the legislative branch imposes taxes.
So without talking as to this case, because who knows, it might come up again, I rather doubt it, but without talking about that case, you feel that that would be judicial activism along that line if a court does impose taxes?
And I think that that's
as its ruling.
Just in the abstract, I think it would be, and I don't know that it would be tolerated.
Thank you, Judge. Let me just touch on another area, a little bit of concern of mine, and you may have answered this, and I might have missed it, and that deals with the Equal Protection Clause, and you've taken a very strong position on the case of Brown versus Board of Education. Its companion case is the Bowling versus Sharp case. So you're familiar with that case?
Yes.
I presume. And as you know, the court recognized the 14th Amendment's Equal Protection Clause does not apply to the federal government. So the court held that the federal law segregating the district schools violated the Due Process Clause of the Fifth Amendment. And the Bowling court ruled that the Fifth Amendment embodied the equality principles of the 14th Amendment. Do you agree with the Bowling decision? Do you have any problems with that?
I have no quarrels with Bowling v. Sharp.
Thank you. And lastly, on the area of literacy, and by the way, I just want to go back to that case. When Judge Bork was here, just so people understand that I make a great distinction so far, Judge Thomas, between you and Judge Bork. Bork was very critical of the Bowling decision, and he said it was a clear rewriting of the Constitution by the Warren Court. He labeled it social engineering from the bench. I don't bring this up to open up wounds or anything else, but I do bring it up to point out that I think you are very different in your philosophy and your approach to the Constitution than Judge Bork was. And as far as I'm concerned, that's important for your confirmation process. In Section 5 of the 14th Amendment, it gives Congress the power to enforce by appropriate legislation the provisions of that particular amendment. Invoking its authority under Section 5, the Congress in 1965 and in 1970 adopted provisions of the Voting Rights Act banning literacy tests in certain instances. And those provisions were upheld in the Katzenbach case and in the Oregon versus Mitchell case. The court held in those cases that Congress had the power to determine that requiring literacy tests in specific instances deprive voters the equal protection of the law. And again, just for the record, Judge Bork told the Senate Judiciary Committee during his confirmation hearing that the Katzenbach was bad constitutional law. How do you feel about that case? Or maybe you've already answered that, but I missed it if you did. Have you had a chance to review that voting rights case, and do you believe that that's the correct interpretation?
Senator, I did read that case. Again, I don't remember all the details of it, and I can't and did not have a basis or any quarrel with the case or the result in the case.
So you feel that is, in your philosophy, a proper interpretation of the Constitution of this particular Section 5?
I just have no quarrel with it, Senator. I don't object to it.
When you say you no quarrel, you mean that you agree with it. Is that fair to say? I
don't disagree with it. I don't have a basis to disagree with it, and haven't raised any objections about it.
Okay, fine. I don't mean to quarrel with you, Judge. It's just a lot easier to say, yeah, I agree with it, than to say I don't have any quarrel with it. It immediately raises a flag in some people's mind that's saying, gee, he won't take a position. And I think you have taken a position. I was just trying to get you to say, yeah, I agree with it, that's all.
Well, I guess the difficulty that I have, I was more apt to say that when I was in the executive branch and be more categorical in answers. You asked me yesterday about my comments at the hearing, the contempt hearing. And my answer was categorical.
Yes, it was.
And you asked me what I learned from that, and the response was not to be categorical. And certainly as a judge, I think that it's important that when I don't know where I stand on something, or I haven't reviewed it in detail, that it's best for me to take a step back and say I have no reason to disagree with it, rather than saying I adopt it as mine.
Well, I guess that's a fair idea, but when we're talking about a literacy test on the right to vote, and if you have read the Katzenbach case or the Oregon case, it doesn't seem unreasonable to say, yeah, I agree with those cases. Now, if a different set of circumstances come up and it's a different kind of literacy test, it seems to me it gives you every ample right once you're on the bench, if you are confirmed, to say, well, this is different than the Katzenbach case. And my only concern is that I think this case, I happen to read them, and you have too. I haven't read all the cases that have been cited here, but I've read this case, and it seems to make imminent sense to me, and my question is, does it make imminent sense to you?
It makes imminent sense to me to find unlawful literacy tests that are used to deprive people of the right to vote.
That's all I want.
And let me just give you...
That's all I'm looking for.
Yeah, I want to give you a quick anecdote as to why it's so important. I can remember my grandfather poring over the Bible in order to, as he said, to go and get his right to vote. And it was a painful experience watching that. So I understand what you're saying. The only point that I was making in the reservation is that the way you approach it and the way you reach that result, but the underlying concern I think we both share.
Oh, I don't think there's any question we share that underlying concern. It's just that we have certain cases that are, are beacons in an area, and these two cases are, and without having you comment on what you're going to do if another voting rights case comes, it just seems, and I think now that you've answered it, that you believe these cases are correct. And that's really all I want to know, and I only say that because I think some people get disturbed up here when they can't get you to say yes or no, and after maybe what I asked you yesterday, you're a little bit leery of saying yes or no, but when there's a case as clear as this, I appreciate the affirmative answer clearly. And that's all the questions I have, Judge, and I want to thank my friend from Massachusetts permitting me to intervene here, and I think there still is some time, Senator Kennedy, on your time, because I don't think I've taken the full 15 minutes.
Thank you, Senator.
Thank you, Judge Thomas.
Well, I understand previous agreement that that would conclude the portion of the hearings for today, and as the chairman has pointed out, we will resume the hearings at 9:30 on Monday morning. Committee stands in recess.
Well, that was an interesting. That was day 4, and let's see. We got past natural law. That dominated days 1, 2, and 3. Are you gonna apply the Constitution or what some framers and founders referred to as natural law, which came down from God? They grilled them about it. It's the Democrats grilling them about it. They're really quizzing them on it. But we got past that today. We got into more stuff about, like, who are you philosophically? Are you the same person that you were back in college 20 years ago? And he said no every time. He was an activist. He was a civil rights guy. Apparently, he was even like I don't know, kind of intimidating at some point. It's hard to imagine. But he's like, no, I'm not that young 20-year-old activist anymore. I'm I think maybe he accredited going to law school. And they asked him, why did you go to law school? I'll have to go back. I have the time. They asked the question, but I didn't really internalize the answer. Other things that they asked him about, I think we talked about, affirmative action, and, he admitted to having been a beneficiary from that system, but also that philosophically he's come a long way, and he thinks that a meritocracy is a better answer, and that, we can see that in his decisions, and since then. They touched on Chevron, which is a decision that has that gave the government, Chevron deference gave government agencies the ability to unilaterally, make rules and some laws in a way, but that was rolled back recently in Loper, and that came up. I need to clip it and and listen to his answer again. But today was a lot more substantive versus, the first 3 days being natural law. What's your opinion on natural law? What about the Constitution and natural law? What about the framers and natural law? So interested to see what tomorrow brings. And then, coming up, everybody wants to see the Anita Hill stuff. I think I've gotten over my conscience telling me, don't do it. I don't think I'm going to get invited to any cocktail parties from Clarence Thomas. I think that's not an issue. But it seems to be something that everybody wants to see. I don't blame you. Can't blame you. My wife wants to see it too. She'll probably come down and watch with me when Anita Hill comes up. Other than that, I'll probably clip some of the more powerful moments from today. Keep an eye out for that. And I don't know. Anything else going on in the chat? It was a lively one. It was a lively one. Why was that the focus? Any files used in the hearing publicly? That's a good question. So you're asking like whether when they read something in like a news article or a book, if those files are available. I haven't gone that deep into it yet. But this has been a focus of mine. Like I said, Congress is in recess, and so that definitely informed my decision to do something. But the reason I landed on this was I had just gotten finished reading not one but two Scalia books. Thomas only has one, I think, book that he wrote about himself, and I'm gonna tackle that, but it was definitely the impetus behind this too. And so I'm gonna wrap it up. I'll answer whatever I can, but bad, unsuccessful, or justified on some insurrection is still an insurrection. I don't, I think if we're talking about Trump, I think, we can throw around the word insurrection, that's fine, but, when I think about the evidence that I've seen, it looks like Pelosi, Diedelbach at the ATF, and a few other agency heads are really guilty for orchestrating it. So, insurrection, yes, I just think we're going to arrive at different conclusions as to who should be guilty. So, I don't know. I appreciate everybody coming in. I'll end it there. Keep an eye out for the clips. We'll be at it again tomorrow. Thank you so much. Be well. Love you guys, by the way. Love you guys. Woo! That's a good